Court is calling 2025 CR 0033530, State versus Vanessa Lynn Maravete. All right, if I can have parties approach. Can I have parties announced, please?
Representative for the state of Texas.
Denny Callahan defense.
And are you Vanessa Maravete?
Yes, ma'am.
All right, you entered a plea to injury to the elderly. According to your plea bargain agreement, the state is silent on your application. And there's an affirmative finding of family violence, and this is run concurrent with a county court cause number. All right, are there any witnesses, defense?
No, Your Honor.
All right, the court will hear your argument.
Your Honor, asked the court to take notice of the jail classification. Its weakness, of course, is that it's self-reported, but it corroborates to some degree what the MEC evaluation says. In the past, she's had mental illness problems, and less so now. And the number 2 point, Your Honor, is that the complainant in this case, in both cases, misdemeanor in your court, not interested in hurting this woman. She filed on prosecution, but there was a damage made by glass broken up against her eyes, so there was damage. She's remorseful for that. Her plan is to live with a 35-year-old friend of hers that she's known for a couple of years. There's no more contact between the boyfriend and the complainant, who is the boyfriend's grandmother. That's finished, that's over. And she doesn't plan to return to that. I asked the court to consider deferred adjudication with some type of supervision regarding where she's gonna live. Nothing further, Your Honor.
Right, so let me understand this. So the facts of this case are that the elderly person was in an argument with her grandson. Is that correct?
No, Your Honor, the other way. The
It says
grandmother
Vikky
with
said
the-
she had been arguing with her grandson and the suspect got involved.
Oh, prior to that, yes, Your Honor, but the real issue was conflict between grandma and her.
All right, you want to raise your right hand? Do you solemnly, right hand? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. State your name for the record.
Vanessa, you know it.
All right, I'm having trouble hearing you.
Louder.
Vanessa, you know it.
All right, so what is your relationship to the victim in this case?
There's no relationship anymore, but I was with her grandson,
All right, so you, and how old are you?
24.
24. And how old is the grandson?
He just turned 20 in January.
All right, and you were living with her?
I was living there for about 5 or 6 years
You were living with her?
with her and the grandson.
All right, but that's her house, right?
Yeah.
It's not the grandson's house. So you come in and you live with the grandmother and the grandson.
Yeah.
And then she gets into an argument with her grandson.
Mhm.
And what was that argument about?
I don't remember the exact details due to the fact that I was.
I'm sorry, I can't hear you.
I don't remember the exact details because I was under the influence.
Under the influence of what?
Xanax.
All right.
Talking to my face.
So she's in an argument with her grandson, and then what do you do?
So I was, I guess, like in the middle, I guess. There was a lot of things going on due to like a lot of abuse.
You have said some things, but you haven't told me anything. So,
Yeah, Your Honor, how
Yeah.
did she get hurt?
So I got pushed into her.
no,
by the grandson.
that's not what this says. Because if you were just pushed into her, then maybe you need a jury trial. If you're saying you were just pushed into her. But that's not what it says. In the police report, it says, while on patrol in a marked vehicle, I was dispatched to the listed location for an assault in progress. The caller stated his brother and the girlfriend were arguing, and the girlfriend hit the grandmother. The caller stated the grandmother was bleeding from her head and nose. I arrived to the listed location and saw both victim 1 and O1 sitting outside on the porch. Victim 1 had visible injuries on her face and head. Victim had a small cut on the bridge of her nose, which was still bleeding. Victim had a small cut on the top of her head that was covered in blood. Victim also had a lump on the right side of her head. Victim said she had been arguing with her grandson. Victim said she had been arguing with her grandson and the suspect got involved and began to argue with her. Victim said she doesn't remember how or what she was hit with, but the suspect walked up to her and hit her. O1 said suspect had threatened to beat up the victim before. So unless you were on Xanax all the time you were at that house?
I was on Xanax for the last 2 years that I was living there.
All right, is there anything else?
Moment, please, Your Honor. Nothing further, Your Honor.
So why were you not living with your parents?
So, and,
Sorry, I cannot hear you.
So I'm from Wisconsin and moved like what, 5 or
You're
6
from the
years
what?
From Wisconsin.
Okay,
And so I moved in with him and I was living with him, basically for both of them because.
did you have a job?
No,
How long have you been unemployed?
since I got with, my grandson,
And how long has that been?
about 6 years ago, 5.
So 6 years you have been unemployed. So why did you leave Wisconsin to hook your life to this person?
It's just being young.
Because your parents said they didn't like him or something, and you decided to do it anyway?
No, I just, my parents was approved, but at the time,
And how old were you when you met him?
so I met when I was 16, but I didn't start a relationship with him until I was 18.
Mhm.
Like about a week after I turned 18.
And how far did you go in school?
9th grade.
9th grade? Yeah, so it sounds to me like you were not listening to your parents. Did your parents want you to get your degree or no?
They did, so I was, taking care of my mom. My mom is disabled, and so I was taking care of her, working at the time, and I had a part-time job going to school. And I was taking care of my mom, which she's disabled, and my little brother who's also with autism. So I felt like I had a lot on my plate, and so I chose to work instead of going to school.
And then you chose to leave them on their own because you wanted your own life.
Well, my mom had got married and stuff, so she met her husband, which he still takes care of.
Mhm. All right, what is your criminal history?
No, I don't believe. A lot of.
No felonies, Your Honor.
So the only history she has are just the 2 cases that have been before your honor, which is this injured elderly and then the concurrent misdemeanor.
Violation of protective order? And is that with the same person?
Yes,
It's with the same person, yes, your
And when did that occur?
honor. That occurred about a month after this took place.
So she had a,
Your Honor, brief summary of those facts if you'd like.
well, what date was the violation of protective order, the offense date?
December 17, 2024. This happened November 27th.
All right. So you want to tell me about this violation of protective order?
So I never like been in trouble before, so I didn't realize like whenever I didn't know how the law worked basically.
Well, I mean, if somebody tells you If you receive an order saying that you can't contact somebody, that's how the law works. The order says you can't contact them.
Yeah.
So continue.
So I had went to pack my stuff, and so I was getting ready to leave, and I guess the grandson had got mad. That I was getting ready to leave because I was wanting to leave him too. I was with him for 6 years, on and off abusive relationship, so because I didn't really have family here in San Antonio, it was harder for me to like just walk away from the relationship.
All right. And what is this case about? The violation of protective order?
So essentially, the same victim in this injured elderly case had concerns that there were other people in the house that doesn't live. So she calls 911, police respond, she lets them into the house and they find this defendant hiding in the closet of her boyfriend's room. And she's removed from the.
All right. So obviously you knew there was a protective order because otherwise you wouldn't be hiding in the closet.
Well, I was forced into the closet. The grandson had threatened me into going into the closet.
The story you're telling me makes absolutely no sense. You have a protective order that you're not supposed to be there. You go there anyway. And now you're saying that you were hiding in the closet because the boyfriend told you to hide in the closet.
Well, he was very abusive. He had weapons and things like that, so I was very afraid of him. My family could testify to the abuse as well. They had called the police on him multiple times before all this occurred.
And when they called the police on him before, what did you do? Did you do an affidavit of non-prosecution or say, my family is not telling the truth?
So they never gave me like the option or like explain that to me how the affidavits work or anything.
No, I
like
mean,
that.
it's either you said
Okay.
yes or no, because times have changed. When the police are called out for an abusive situation, your attorney will tell you somebody's getting arrested.
Yeah, so.
Now, after the
he would
fact,
get arrested and sorry,
Mhm.
his sister would bail him out, within like a few hours, so he would be home immediately after being arrested. So even when he had a protective order, the first time he got arrested, he was still back and he was. still
Because that's-
listening.
because the protective order, that the house you were staying in, that's not your house, that's his grandmother's house. You all are adults just decided to impose yourself on his grandmother. You're there, you don't have a job, and you're just living off the grandmother.
No.
And
I
now-
have income, still from my family.
No, you told me that you hadn't worked in 5 years or 6 years.
Yeah, so due to the relationship, I wasn't able to work and I also didn't have, like, my birth certificate for a long time, so I had to get it sent out.
Here's the thing, I don't even know if you understand what you're saying to me. You keep changing your story. You told me you didn't have employment, that you hadn't worked for 5 to 6 years. And then now you're telling me, no, I wasn't just living off the grandmother. I had my own money. No, you didn't. You hadn't been working. I mean, you're saying, but you're telling me completely different stories. And
Well, I
now
was-
you're telling me that you have a 35-year-old that you're gonna live with. Who is this 35-year-old?
It's a friend of mine.
Who?
I don't know how to explain it. It's a friend of mine,
What's the name?
Jennifer
Jennifer what?
Ramos.
And where did you meet her?
So me and her know each other through mutual friends, and then we met, I don't know, I guess like in the neighborhood and stuff.
I'm sorry, met what?
In the neighborhood, I guess, or I don't know.
So you're just meeting people in the neighborhood and now you're gonna live with them? Does she have any children? What are their ages?
23, she has a 23-year-old, a 15-year-old. And then she has one that I think is like 10 years old.
All right, so if I give you probation, I'm not allowing you to live in homes that have children in them. So, and do you know who all lives in that home other than her and the children?
No, it's just them.
Hmm?
It's just them.
Are you sure? Have you been to the house? Do you know she has a boyfriend?
She doesn't have one.
All right, so when have you been to the house?
So I was there once. I don't remember exactly when, like I said, I was like,
Was that before or after the violation of protective order?
that was before.
All right, counsel, I don't know if she would be a good candidate for probation. I really don't know.
The remedy of sending to prison is a far worse remedy than trying to find a place for her to live, Your Honor.
Well, I know the state is asking for the minimum. And she applied for deferred adjudication.
He suggests family going back to family in Wisconsin.
What I can, what I can tell you is you've applied for deferred adjudication. The state, according to the plea bargain agreement, they're asking that if I find you guilty, that your punishment be sentenced to 2 years in the prison. That's the minimum. If I grant your application for deferred adjudication and you're unsuccessful, you're looking at 10 years in the prison, potentially. Do you understand? So I can grant your application for deferred adjudication, or I can sentence you to 2 years in the prison. And the conditions that you receive are the conditions that you receive from me. There's no need to argue about the conditions that I'm gonna set for you if I grant your application. So do you want the minimum 2 years in prison, or do you want to be on deferred adjudication with the court's conditions? Are you sure? Because let me just tell you, you know yourself better than your attorney knows you, better than I know you. I know that you've been dishonest with me today, but your choices are, and you need to think long and hard about it. 2 years is the minimum. The range of punishment for this offense is anywhere from 2 to 10 years in prison. If I grant you deferred adjudication, if for some reason your deferred adjudication is revoked, you're looking at potentially 10 years in the prison and up to a $10,000 fine. So you know whether or not you can complete this successfully or not. Part of being on probation is you are not allowed to use drugs, period. There's no marijuana, there's no Xanax, none of that. And I'm not going to allow you to reside in any home with children. You're an adult. You need to get your own place. You need to stop depending on other people. Do you understand? So, do you want the 2 years in the prison or do you want deferred adjudication? All right. Yes. Yes. All right. This is what the court will do. The court is going to sentence you to 8 years deferred adjudication. There's a $1,500 fine. Time and money will run concurrently. Oh, I'm sorry, state. Oh, you're right. Thank you. State your excuse. I appreciate that. So there's a $1,500 fine probated. Proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. There's to be no residing with minors or anyone over the age of 55. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. There's an affirmative finding of family violence. There's to be no contact with Carmen Rivas or Hector Rivas. This is to run concurrent with 2025 CC 003873. Can I see the MIC evaluation again, please? Thank you. Thank you. In custody, the following: a referral to felony drug court and a TAP evaluation. If not accepted in felony drug court, follow all TAP recommendations. There should be 200 hours of community service restitution. 100 of those hours will be deemed satisfied. You're going to obtain your GED. Do you understand? And the other 100 hours will be deemed satisfied if she obtains some type of trade school certificate or higher level of education. Do you have any children?
No,
All right, and you're saying you're thinking about a transfer to Wisconsin?
yes.
Which county?
I'm not sure the exact county, but it's in Milwaukee.
All right, let me see what Google tells us. No, they're saying it's Milwaukee County. So transfer to Milwaukee County. Field visits one time per month until further notice. And 90 sober meetings in 90 days. Probation, is there anything else? Is there anything else you need from the court in order to be successful? All right, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, yes.
Judge, can you repeat the sober support meetings?
90,
Okay, and anger management possibly?
yes. I'll add anger management. All right, we can go off the record. Here's the thing, before you get in another relationship with anyone else, you need to get your life together and decide who you are and what you want to do in this world. You understand? She's in her world. Maybe probation will help her. Good luck.
Thank you, Judge.
You're welcome.
Right over here, man.
All right, sorry, I know. All right, so here's what the court doesn't understand. There's a new number 1 and there are 2 violations of condition number 41. So why are you all not proceeding on those violations?
Not aware of why that's, Judge. I was just instructed by the attorney assigned to this case that they just wanted to withdraw the MTR and hold off on proceeding before that new number 1 was ready, since that would probably be the strongest basis to argue for revocation.
Well, you all need to confer because he has a violation of conditions number 41. That means that if those are true, that's something that needs to be done, because obviously if that was true, there's something wrong with his UAs, maybe, I don't know. And he's on probation for driving while intoxicated. So do y'all want to talk to probation about that?
We have a little bit, Judge,
Okay.
about potentially altering and amending. We
Well, is the defense in agreement to altering and amending?
Judge, we've talked about altering, amending and adding a couple of conditions.
And what would those be?
ISP, sober support meetings, potentially GPS if he is able to bond out. I think the bonds are fairly high on his new cases. But while I think that's unlikely, we put a few conditions in place for that.
Probation? Oh, I'm sorry. So they're saying that they want to withdraw the motion. And they're saying ISP and,
I just don't know that felony drug court will take him back at this point, Judge.
oh, no, they're not.
Right, so I did recommend GPS, intensive supervision, sober support meetings, and the IVR hotline.
And Judge, he does have the ignition interlock and has had it.
All right.
And the other, I'm just handing that to you, Judge, the other. When he submitted other UAs, Judge, there's other 2, so I believe there are 4 total that he submitted. And 2 of them were negative and 2 of them were diluted, so it was negative, dilute, and then negative.
And I'm not aware of any ignition interlock violation.
I'm not aware of any either, Judge.
All right, so you're asking that the motion to be withdrawn, and of course, the court can't proceed if nobody's presenting any evidence. And the alternate amend, so withdraw motion. Alter and amend to include So are y'all requesting full GPS?
Yes.
One of the conditions, should he make bond, is partial, and we would be asking for partial.
For what purpose? Partial for?
Uh, Yeah, good point, Your Honor.
All right. What I'm going to do is I'm going to do full GPS. Once he provides proof that he's employed, the court will reconsider.
Thank you, Your Honor.
All right, so there'll be full GPS. Waive fees. ISP. And how many sober meetings probation?
Judge, it was 90.
All right, there'll be 90 sober meetings in 90 days. Is there anything else probation?
On it, or IVR hotline or just continue with it.
Just continue with the ignition interlock. All right. Is there anything else you need from the court?
No.
Anything else from either side?
Judge, I'll just ask, are the 90 meetings Zoom or is that in person?
He can do that by Zoom. I believe they have Zoom. If they don't, just let probation know and we'll figure something else out.
While he's in custody.
No,
Okay, so.
it's gonna have to be when he's, well, I will tell you this. I take that back. I said no too quickly. At the jail, they do have classes that they can take that the court will find acceptable to the 90.
Okay,
Okay. All right, is there anything else?
no, Your Honor.
All right, thank you. Thank
Be
you.
excused.
Yes,
Thanks, Judge.
you're welcome. Thanks for standing in.
Yes.
All right, who's here on early? Hernandez? All right, the court is calling 2025 CR 0018028 and 2025 CR 0018001B, State versus Early Ramirez Hernandez. Can I have parties announce?
Rafael Leal for Mr. Ramirez Hernandez.
All right, and we have an interpreter here. If you could raise your right hand, please. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do.
All right, you can lower your hand if you'll state your name for the record.
Bean Abrams, license number 2081.
And I previously asked this before, and I know the answer, but Mr. Leal, do you speak Spanish fluently?
Yes, Your Honor.
And have you been able to communicate with your client about this hearing?
Yes, Your Honor.
All right. Mr. Hernandez, you entered a plea of no contest in each of these cause numbers. In each of the cause numbers, you submitted an application for deferred adjudication. And each of the cause numbers, the state is silent on your application. They're asking that your punishment be assessed at a cap of 12 years. The cases are to run concurrently, and they're taking in consideration 2024 CR 00180, 2025 CR 00180B, 2024 CC 742954. And at your entering of the plea, the court informed you that if the court were to find that there was sufficient evidence to find that a weapon were used, the court would enter an affirmative finding of deadly weapon. Counsel, do you have any witnesses?
Your Honor, before we proceed, I have a mitigation expert
Yes.
that has interviewed Mr. Ramirez Hernandez, and he's asking me, this is a mitigation expert from MAC, the Management Assigned Counsel. And he asked me to request that he will need additional time to give me a report and provide more information concerning Mr. Ramirez Hernandez social history and mitigation evidence.
And how much time is he requesting?
He asking me for 30 days.
I understand you. So you want to call him and let him know, tell him that if he has already interviewed him, and this case has been, I mean, since May 30th is when the plea was entered. So if you want to call him and see if,
He says that, Judge, that he was planning on meeting with him two or three more times to properly develop that.
I can, I'll give you to the week of July 14th. And he needs to have it done by then.
Oh, yes, absolutely.
So will he have it done by then?
I'm sure.
All right, Ms. Ferguson, recall this for July 14th. All right, thank you.
Thank you, Judge.
You're welcome.
For Viviana Sanchez.
Could I see the file on Vivianca Sanchez, please?
Yes.
All right, so the state is asking that your case to be dismissed. They're saying the reason why they're asking it to be dismissed and for me to sign it is because there is a missing witness. Do you understand?
Yes.
So whatever brought you here today, make sure that doesn't bring you back here. Do you
Yes.
understand? If there's an issue with mental health, if there's an issue with any type of drug addiction, if you can't find a place, because there are plenty of free places, if you come back here, let me know. I'll pick up the phone and call somebody to help you, okay? There you go. Drive safely.
Thank
The
you so
weather is
much.
bad. You're welcome.
Thank you.
All right. Is any one of them, Medellin? If you come forward, please.
So we'll get you up to this black tape here.
Sure.
Hi. So I wanted to let you know that your attorney couldn't be here today. So he will see you on June 26th, okay? Do
Yes, ma'am.
you have any questions?
No, ma'am, I don't.
All right. So I didn't want you to be brought over and not know what was going on.
Yes, ma'am. Matter of fact, I do have one question.
Sure.
Um,
If it's something I can answer, I'll answer it. If it's something best for your attorney to answer, I'll let him answer it.
I'm here right now on this robbery case, but also, I, have an MTR and it's not showing any type of paperwork and, they're not telling me nothing about it. So I don't have no hold or no blue one or nothing. I have
So-
on.
You want to know about the motion to
I
revoke?
just want to know if it's active or they unsuccessful discharge me or anything. I'm not, nobody's telling me anything. And they,
So we'll find out about that and make sure you have a copy of your motion to revoke, okay? If it's still active.
it's not,
All right, thank you. Just have a seat. We'll get that for you.
thank you.
And Jessica Garcia's out here too, Judge.
Okay. Oh, and Deputy Laura, there's like loud, I'm getting,
June 26th.
yes. All right, and then Jessica Garcia. If you come down, please. Hello.
Hello.
Hi, your attorney couldn't be here today. They said they were not aware of this setting, which I can understand why they wouldn't be aware of it because you didn't report for court, so that's why you have the bond forfeiture. So they're asking that your case be recalled for next week. So they're going to bring you here on Monday. All right?
Yes, ma'am.
All right, thank you. All right, Mr. Medellin. Probation said they don't even see you as being on probation. So maybe is your probation in this court?
Parole?
Oh, we don't handle parole. So that will be with the parole board. That's a whole different governmental entity.
Okay, thank you.
You're welcome. All right, Ashley Jones. Hello,
Morning,
Jones.
Judge. How are you?
All right, how's it going?
Very well, thank you.
We all survived the rain.
Lots of it.
Oh, I was just like, please, you know, the lightning, please don't hit this tree because
Oh.
my neighbor wants my tree cut down. And I'm like, the last thing I need is to be out of the house again.
Yeah. Oh, God. Oh, Lord.
For another year. Yeah, it's like a year and 6 months it was beautiful though, but you know. All right, so the first thing I have here is I have the state asking to amend the indictment. Have you had notice of this, counsel?
I have not. My first appearance with Ms. Jones, so
Okay. And so I know it's your first appearance, but if that's something you're gonna have an objection to.
No, I don't object to this, Judge.
All right, so we'll put that on the record and we'll make sure you have a copy of that.
Yes, Judge.
All right, the court is calling 2025 CR 002-139, State versus Ashley Jones. Could I have parties announced?
Charles Buck for Ms. Jones.
And are you Ms. Jones? Yes. All right, the state has filed a motion to amend the indictment. And state specifically, what are you asking for in the amendment?
Judge, if I could.
And I think that was filed by someone other than you.
Judge, so we are asking for the term that the grand jury was held to change from 2026 to 2025.
All right, defense, any objection?
No, Judge.
So that will be granted. All right, and I know, State, you're probably not prepared today, but the defense has filed a motion to suppress evidence. And counsel, what is it based upon? Just a general idea?
Just, those motions, Judge, are just
General, okay.
general, yes. So at this time, we're not asking for those to be heard.
All right, so counsel, I know this is, you say this is your first
It is.
appearance. Then you don't know if you have all discovery or not.
I do not know yet. Mr. Stout is present, is the special prosecutor for the State Board of Insurance. He's present in the back as well. So I've been conferring with him. He and I are going to confer. He's going to get me all the discovery. So
So,
asking for like 45 days if we could,
all right, so do y'all think it's gonna take 45 days?
for me to review all the discovery.
No, I mean for you to receive it, because I.
No, I don't
just-
think it'll take that long to get the discovery, but just for me to get it and review it and then return to the court.
All right, is there a need for a flash drive or
I don't-
external
I don't
hard
think
drive?
so.
All right, Ms. Ferguson, reset this for discovery for 30 days. It's just to make sure you
Yes,
have
Judge.
everything.
Yes, Judge. Okay.
July 10th. All right, on July 10th, we'll come back for discovery and state. Will you be prepared at that time to tender an offer?
Yes, Judge. I think there's an offer formulated. It will be tendered.
All right.
Yes, Judge.
All right. Once you sign the reset form, you are excused. Just have a seat. Thank you for dressing appropriately for court. Thank you. All right, who is here on Erica Arovala? Are you all ready to proceed?
Yes, ma'am.
Court is calling 2020 CR 5583 State versus Erica Ann Arevalo. Could I have parties announced?
I think I'll let them say it.
Lindsay Shaw for Mr. Revel.
And are you Miss Arevalo?
Yes, madam.
All right, did you review the documents entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and State's motion to supplement pending motion to enter adjudication of guilt and revoke probation with your attorney?
Yes,
And did you understand it?
yes,
Are you the same Erica Ann Arevalo who was placed on deferred adjudication in 2020 CR 5583 for the offense of possession with intent to deliver a controlled substance, penalty group 1, 4 to 200 grams on January 13th, 2021 for a period of 5 years? Is that you?
I'm sorry, so I was going off of, this might be my mistake, on the front page of the MTR, it shows just she's on for straight possession.
No, it's possession with.
Well, I
Yeah.
see that now. I'm sorry to interrupt you.
No. Do you need to confer?
I do, because on the first page of just the MTR, not that, but the court summary, it showed that it was just straight. No, from probation, the court summary.
It's a court.
Ah, okay.
It should, yeah, so I only discussed the fact, I thought it was a second degree. So if I may, I'm sorry,
Yes,
Judge.
no problem. It happens. Mr. Featherston, are you ready?
Yes, Your Honor, Your
All right, Ethan Gonzalez. Hello. All right. Let me,
Judge,
obviously is pulling up his case.
okay, can we go off the internet for just a minute?
Sure, just give me 1 second.
Or on the internet?
No problem. All right. You'll need to file those motions.
Yes, Your Honor.
All right, Ms. Ferguson, I need a 45-day reset, please.
And Judge, as to discovery on the case,
Mhm.
I still have not looked at all the data yet.
Okay,
But I think that 45-day reset will probably take care of that.
okay,
28 July, okay.
all right, we'll do July 28th. All right, we're back on the record in 2020 CR 5583 State versus Erica and Arevalo. Could I have parties re-announced, please?
Megan Gallagher for the state.
Lindsay Shaw for Mr. Revelo.
All right, Ms. Arevalo, you reviewed the motion to enter adjudication of guilt and revoke community supervision and state's motion to supplement pending motion to enter adjudication of guilt and revoke probation with your attorney?
Yes.
Did you understand it?
Yes.
Are you the same Erica Ann Arevalo who was placed on deferred adjudication in 2020 CR 5583 for the offense of possession with intent to deliver controlled substance penalty group 1, 4 grams to 200 grams on January 13, 2021 for a period of 5 years? Is that you?
Yes.
All right, state.
The state's gonna be pursuing on the motion to supplement the motion to introduce guilt to not accomplish.
Yes.
So violation of condition number 5 in Dare County, Texas, the defendant Erica Ann Arevalo did then and there fail to report to the supervising officer as directed for the months of January, February, March, April, May, June, July, August, September, October, November, and December 2024 in violation of condition number 5.
How do you plead to that? True or not true?
And we'll wait and abandon it.
Any objection to the
No,
waivers?
Judge.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, sentence you up to 5 years or 99 years or life in prison and up to $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 5? No. Do you still wish to plead true, knowing that I could send you to prison for life?
Yes.
All right, the court will find violation of condition number 5 true. Is there a proposed agreement?
Judge, there's not, state is asking for revocation, given the defendants gave true and in compliance with reporting on conditions of probation.
All right, in defense, what are you requesting?
Judge, if you look at the court summary, probation was recommending SATIF. And in this case, we are asking that the court consider something lesser than sending Ms. Arevalo to prison. We obviously, by pleading true, she understands that it was wrong to not report for over 2 years. But I would like to point out from January of 2021 until July of 2023, she did report. She was reporting. She did complete the outpatient treatment program, and she was holding down a full-time job. That job, which she still has, well, did have until she was arrested last month. She's a full-time cashier at a Shell gas station. It's the same job she had when she got this probation. And when she stopped reporting in July of 2023, and I'm gonna have her speak to the court, but she sort of got tasked with helping take care of her disabled mother. She's also been helping her grandchild, helping take care of her 5-year-old granddaughter who has so she's special needs. She has a feeding tube. There's a lot of issues going on. And so she put that above taking care of herself and doing what she was supposed to do by reporting to probation. She has no criminal history besides this felony case. She does not have any other felonies. She's never been on any other type of deferred adjudication. And she's never been to prison, obviously. So we're asking the court punish her by sending her to a treatment facility, but give her a second chance before she's gets a felony conviction and has to go to TDC. And if I would like to call Miss Arevalo.
All right, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Yeah.
All right, you may proceed.
Okay, Erica, I want you to tell the judge, why should she give you this opportunity? Why should she not revoke you and continue you on probation? Can you tell the court?
You can give me a second chance. I'm more better out there of service out there in the world than I am in prison. Never been to prison. This is actually my first time ever being locked up this long. I'm actually a lot, I did a whole 180. That was in 2020. I work now. I am actually a grandmother. I still take care of my kids. I still, my son lives with me. I help my mother because she's disabled. My brother was her provider, but then he passed away like 3 months ago. So I've been having to help her, help my daughter with her special needs. She's blind and eats through a feeding tube. So I also have to help her. I'm a babysitter for my other daughter while I'm not working. So I don't want the felony on my record because then it would be harder for me to get a job. So if you could just take a chance on me again. I'm actually a lot better out there than I am here. And I'm not even a criminal. I've never even.
No, I mean, you had drugs that you intended to deliver. They were in baggies. And what I can tell you is everybody in the box will tell me that they're better in the real world than being in prison. And one of your conditions of probation that you just testified to violating is that I ordered that you were not to have unsupervised contact with minors and you're babysitting. And the reason why I ordered that is because you have possession with intent to deliver drugs. And it was a lot of drugs.
No, I mean, that's not the reason why I totally dropped all of that when my grandkids came up, because how am I gonna help them if I'm in prison? So that's basically.
I mean, all you had to do was report.
I mean, basically, I've been taking care of everybody else besides myself. And
So honestly, basically, you haven't been doing probation. You know, a lot of people feel as though when they're on probation, they're supposed to report and do certain things. Those are called their conditions. And they're just like, well, I know I didn't do anything on probation, but I didn't pick up any new offenses. I'm just out here living my life. If that's the case, then you're not really on probation because you're not reporting, you're not doing anything that you're supposed to do. You're just living your life. And when people come before me and they say, I know I haven't reported for over a year, which you haven't reported for over a year, but I didn't pick up any new cases. Do you know that is not really saying anything? Because there are a lot of people who are not on probation and who haven't picked up any new cases. That's like the bare minimum. Don't pick up any new cases. Don't, join a gang. So you haven't done anything on probation. What have you done?
I've been working and helping out my family and.
No, what have you done on probation?
Oh, I mean, I did that class and I was doing everything until I ended up having to move in with my mom, and then she ended up losing her housing. And I mean, I know it, life is like the dumbest, but actually I've been living life trying to better myself and do you know, if you could just give me, I've never even been to prison. I'm sorry, I don't want this on my record, because then it's gonna be harder for me to even get a job when I do get, say you do send me. I mean, it's kind of gonna be even harder for me to. So if I could, please don't send me to prison. Not a prison person. Not,
I don't know anybody who's a prison person, really. But here's the thing, these are consequences to actions, right? So you're not reporting, there was a consequence to that. You could potentially end up being revoked. And I usually tell people, hey, if you think that some action you're going to take could potentially result in you going to prison, then don't do it. If you think it may happen, then don't do it. And you did it. You didn't report. Nobody's seen you for a year. Everything that you're telling me now, nobody's seen you for a year.
I mean, I've had a job for 2 years, so I mean, I wasn't on the run. I mean, I barely started getting child support. Like, I barely started getting my income tax.
No, I mean, I understand what you're saying, but you're on probation for possession with intent to deliver drugs. That means that you have drugs for selling and they were packaged for selling. And you were given deferred adjudication, 5 years deferred adjudication, and nobody's seen you.
Little tricky or.
This is what the court is gonna do. The court is gonna find violation of condition number 5 true. The court is gonna find you guilty. The court will revoke. I'll take into consideration that the fact that she hasn't picked up any new offenses. And I'll sentence her to 5 years in the prison, give her credit for any time served, and request the therapeutic community. And there's to be no unsupervised contact with minors. And there's a $1,500 fine, time, and money to run concurrently. Let's see. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? And did you sign it? You have a limited right to appeal. That right to appeal is as it relates to the allegation in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. Who's there on Devin Berry? All right, so where are we on discovery?
Discovery is just about complete. The 2 more reports I need, and Jason will get them for me today, Your Honor. We get a short setting. I think we can sign off on discovery and perhaps resolve the case.
All right, and has an offer been tendered?
I didn't want to get an offer until all the facts in front of me. That's why I need those 2 reports.
All right, let me see here. State,
Yes, Judge.
on this case, how much time do you need to give him the reports he says he needs?
Reports that I haven't looked at it, Judge, but I mean, I believe they'd probably be on therapy.
Okay,
And that it could, I mean, I don't know, so it is, e-discovery's been wishy-washy,
Yeah.
so it won't be that much time, it's a couple of weeks, Judge, for the state's point of view.
all right, Norma, if you'll put this for July 17th and state at that time, you'll need to be prepared to tender an offer. All right, thank you. Once you sign the reset form, you're excused.
Thank
Thank
you,
you.
Judge. May I be excused?
Oh,
Have a
after
good
he
day.
signs the, you
Yeah.
too, have a good one. All right, who is here on Cody Harris?
You're welcome, Judge.
Hello, where's he?
He's in Mathis, Texas.
Why isn't he here?
He said that we didn't have a telephone number for him, and so I had my office call the bondsman. We finally got in touch with him. He said he didn't know about today's date, but he has a bondsman, so I'm not sure how much I'll believe that, but I can have him come back. This is the first contact we've had with him. He never called us.
All right, you want to have him zoom in?
Guess I could.
All right, if you'll speak to the coordinator about having him zoom in. All right, who is here on David Graham?
Hey, Judge. Good morning.
Good morning. And this is a plea with an application.
Yes, Your Honor.
All right, probation, this is an application. It's on David Richard Graham. Court is calling 2025 CR 001088 State versus David Richard Graham. Can I have parties announced?
Roberto Ambrosino for the defense.
And are you Mr. Graham?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
I have.
Court will find that the state is in compliance with discovery. Mr. Graham, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
No, Judge. Waiving the repeat or offender enhancement allegation. No objection.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Graham, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 2 years in the state jail facility. The state recommends community supervision. They'll take into consideration 2024 AL 005161. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
There have not.
Outside the agreement, the state is requesting that your community supervision be for a term of 4 years. There will be random UAs and random field visits. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
No objection.
State, you may be excused. Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find that there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Just ask that you hold the plea bargain.
All right, Mr. Graham, have you ever had any mental health diagnosis in the past?
Yes, I have.
All right, and what has that been for?
PTSD, depression, and bipolar.
All right, so I'm looking at your history just based upon what's in the indictment. Is there some reason why in the months of May you tend to fall off?
Bad time for me. I lost parents during that time. Also just brings back a lot of memories from early 90s, serving,
Okay,
and just, I kind of, guess I go off the end, I am seeking help for it. I am looking to the VA for more mental health, more help. Center for Health Care has offered help, offered help for me. So I am looking into that. It's real hard for me to during certain times and months of the year. I do get my flashbacks and just especially with that.
So Sean, do you know if somebody from a Veterans Treatment Court can come up? All right, so we're gonna see if somebody from Veterans Treatment Court can perhaps help you, all right?
Okay.
And they can get you in touch and be a liaison between you and your treatment. And I'll see if maybe Veterans Treatment Court will accept him into their program. Because I don't have the manpower to be able to see you on a weekly basis or on a daily basis. But they'll be able to work with you and make sure that if there are any issues or anything you want to discuss, they'll make sure that you have someone that you can discuss that with, okay?
Mm.
All right, do you have any children?
I have one 15-year-old with their mother. I had no
All right, do you have any other family support?
basically, I have nephews, but it's just considering my actions in the past and what things are gone. I've kind of pushed myself away from my family due to that reason.
Okay,
Is I know at times I am very unstable,
okay.
and I just prefer to not endanger anybody else and keep to myself.
All right. And so this apartment where you were staying at, if you're released, do you have a place to stay, or that's gonna be something that you'll need to work out?
That's gonna have to work out now. In fact, I was possibly going to, I need to get out of sleep. That's number one in my book. That's where a lot of bad things. I need to get in the country where it's less, I guess, less people to see, want to come find more there. Somewhere just in an open area, and I have a spot that I'm looking.
Okay.
I was looking at until I got arrested.
Mhm.
But I need to get back to these people and talk with them, to work with them about my check, my pension I received and all.
All right. So when we're gonna have somebody from VA come down to speak to you, and I'm gonna recommend that you be referred to the Veterans Treatment Court. So they're gonna come and speak to you. I'm gonna send it to you now, and they're gonna come speak to you. And if there's anything else that you need, they'll let me know, okay?
Okay.
And they'll be able to confer with you and make sure that you
Okay, I just got
have the
out,
right people.
I just got out of a rehab facility that the VA has for the
Okay.
Serena. So I just got out of there.
All right. So this is what I'm gonna do. There's gonna be regular reporting by Zoom or in person, regular random UAs. There's gonna be a referral to Veterans Treatment Court. And if he's not accepted, then we'll do a referral to the mental health court. Counsel with the mental health court, it's a pretrial diversion program. So you can speak to them if he's not accepted and just let them know that if he is accepted, I'm sure the state will have no objection to filing a motion for new trial and I'll grant it. And that way he can be in that program.
Okay, what about for the Center for Healthcare, ma'am?
Oh, they'll take all, they're gonna, Veterans Treatment Court will help you with that.
Okay, because where I was staying out, being homeless and stuff, I ran across two people that worked there. They gave me their numbers and they turned around and told me just to let the courts know that I already kind of have a shoot in with them. I just need to get back, once again.
No, they'll help you with that, okay?
Okay, I have their numbers, like I say, I'm just, want to
Yes.
confirm that, that you have that there, then I'm gonna go to.
Okay,
As soon as I get released from here, I got the direct numbers, not the office number.
all
I
right,
have the people's direct numbers to call them.
okay.
So I can work with this.
All right, thank you for letting me know. All right, and there, if not accepted to Veterans Treatment Court, then a referral to Mental Health Court. Sentence him to 2 years in the state jail facility, suspended and probated for 4 years. Take in consideration 2024 AL 005151. There will be field visits 1 time per month until accepted in VTC or mental health court. TAP evaluation. That can be out of custody. You're gonna have to make sure that you make all of these appointments. If you don't, a warrant is gonna be issued and then they may end up being done in custody. You understand?
Ma'am.
And we can do a MIC evaluation. And the MIC evaluation, Ms. Abrams, only if VTC doesn't accept him. Probation, is there anything else he needs? All right, I'm sorry.
Yeah, I'm
All right,
okay with
proof
that.
of employment or SSI
Yeah, let me just.
within 45 days. You just provide that proof to them, okay?
Had a problem.
And if he doesn't, and if he's employed, there's to be no employment as a home healthcare provider or with minors. I'm not gonna give him any community service hours.
Thank you.
He's served his country, and I think the issue with him, we need to focus on his mental health, and there are gonna be a lot of appointments for him.
Thank you.
But I am gonna make you do sober meetings,
That's fine.
because you need that. So we'll do 60 sober meetings in 60 days. Is there anything else, probation? Is there anything else you need from the court?
No, ma'am. Thank you.
You're welcome. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, so we can go off the record. Probation, they want you to be successful. Your attorney wants you to be successful. State wants you to be successful. I want you to be successful. If I didn't think you could do it, I wouldn't have followed this plea bargain agreement.
Yes.
So if you need help with something, you're gonna have to pick up the phone and call someone, because we can't help you if we don't know about it, all right?
Yes, ma'am.
And when you reach out to probation, if you feel they're not addressing the issue, you can always come back to court, okay?
Yes, ma'am.
So I'm gonna have you remain out here. Somebody from Veterans Treatment Court is gonna come and speak to you.
Thank you, ma'am.
And then counsel, if you can look into speaking with mental health court to let them know that we'll do a motion for new trial if they're going to accept him.
Okay.
All right, thank you. All right, who is here on Ronnie Benson? And are you both parties ready to proceed on the motion to revoke?
Yes, Judge.
Yes, Your Honor.
All right, the court is calling 2020 CR 8253W State versus Ronnie Benson. Could I have parties announced, please?
Andrew Harrison, stay.
Rafael Leal for Mr. Benson.
And are you Ronnie Benson? Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am, but I couldn't read it because I didn't have my reading glasses, so
Oh,
he explained it to me. But I told him, I said, I already been tried on this case.
no, you have not. So what has happened is you're on probation for driving while intoxicated third or more. And there are conditions that are set for your probation. So technically, you pled to the DWI, so that's not what you're here for today. You're not here for a DWI from 2020. What you're here for is they're saying that while you were on probation, you did not do something or you violated some condition.
Yes, it was my doctor, he changed my medicine and I came.
No. Here's the thing. That doesn't address these issues because none of these allegations in the motion has anything to do about your doctor. It has different conditions. So what's going to end up happening, if both parties are ready to proceed, the state is going to read what they said you did not do. You're going to enter a plea of true or not true, and then I'll make a decision. Do you understand? All right, so are you the same Ronnie Benson who was placed on community supervision in 2020 CR 8253W for the offense of driving while intoxicated third or more on August 27, 2020 for a term of 6 years? Is that you?
Yes, ma'am.
All right, state.
Offer about the 17th day of March 2025 in Garrett County, Texas. The defendant, Tawny Benson, is in there about to submit to the testimony as directed by the court/supervision officer in violation of condition number 2.
How do you plead to that? True or not true?
True.
State waives the remaining violation obligation.
Any objections to the waivers?
No, Your Honor.
All right, did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, and sentence you up to 6 years in the prison and up to a $1,500 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 2? Court will find violation of condition number 2 true. Is there a proposed agreement?
Yes, Judge, amend conditions, deny the motion, amend conditions for weekly UAs for 30 days, followed by monthly thereafter, intensive outpatient with PCC SCD and documented sober support readings as recommended by TAB.
All right, so what has he done on probation?
Judge, he has been, aside from those violations, he has been compliant to a substantial amount of the conditions. He is, for all practical purposes, not employed where he's paid with money. He's paid with by giving him a place to live and kind of like room and board. That's how he gets paid, and he gets SSI of $900 a month. So that's one of he's behind in payments, but that's his economic situation. Most of the, aside from those allegations, Judge, he has a bunch of tests that are negative. And we're asking that the court agree with the recommendation and give him those conditions and place him back on regular supervision.
Probation?
Judge, Mr. Benson was in drug court from May of 2021 to March of 2023. Completion of that program, he did the DWI intervention. He has gone through one round of outpatient treatment. He's finished his victim impact panel. He was on the transdermal alcohol monitor. He finished that. He did the required sober support meetings. He has completed most of the terms of his probation. It's just the with these slight violations.
You want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Tony Benson,
All right, Mr. Benson, do you want to go to prison?
no ma'am.
Then why are you not doing what's required?
I've been doing everything they asked me to do.
But why do you submit to the drug testing?
Did everything I could.
No. They said, and you just pled true to not testing. Why didn't you test?
I probably didn't have a way,
Did you call somebody and say, I don't have a way to come in to test?
I believe I told the judge.
No. Because I'm the judge. You didn't tell me.
Oh, I thought it was good for.
All right, but you've completed drug court. That's why you're back here. You're back here and your case was not, usually they will terminate your probation when you complete drug court. But the reason why they didn't in your case is because there is no early termination for DWIs.
That's right.
So
I did everything they asked me.
they asked you to submit a UA and you didn't. So my question is, why didn't you do that?
I probably didn't have a way, or I didn't have the money.
Did you call somebody?
I called, well, not here, I didn't. But when I was in drug court, I did.
All right, probation, what are you all asking for?
Judge, this is state educated, for weekly UAs for 30 days, monthly thereafter, into outpatient treatment and documented sober support.
How often are you doing sober support meetings before you were taken into custody?
I was just doing probation and doing UA and reporting every month.
All right, so here's the thing. When you're on probation and you have a drug or alcohol problem, you have to stay vigilant. Otherwise, you're going to backslide. And it starts by missing a UA and not telling somebody about it, not picking up the phone and giving them a reason why you may not be able to make it. And then the next thing you know, you look up and you're back where you were before. And that's what's happening to you. Now, if you want to go to prison, I will send you to prison today for 2 years. You'll be done. You'll get credit for any time that you successfully completed inpatient treatment. Otherwise, you're going to finish this probation. What would you prefer?
Stay free.
All right, there's going to be intensive outpatient treatment, 90 sober meetings in 90 days. And there will be regular UAs. And he's to continue with ignition interlock until further notice. Yes.
I don't know that it has interlock. I see that it has a portable device.
Do you have a vehicle?
I have a vehicle, but it's not running.
All right, you need to provide proof of that. And with an affidavit of non-driving and proof of an operable vehicle, then he can do the portable monitoring device until further notice. Is there anything else you need from the court? You better do better. And remember all of the tools that you have been given to not backslide. You understand? People, places, and things, and you have to take accountability. All right? All right, good luck to you in this court. If you need something, you can call probation. If you feel they're not addressing it, you can always come back. All right, where's Anita? All right, let's take your case.
The prosecutor is sentencing across the hall that she thinks is gonna take quite a while. We've briefly conferred, we just did the competency disposition yesterday. He was found competent to stand trial. And so we'll be conferring, trying to reach a resolution. We're both parties are requesting a reset.
Okay, did you have them pull the file?
Yes, I believe so.
Okay. All right, I'm coming through these and I'll get to it as quickly as possible. I'm just
Okay.
waiting for them to put it here.
Oh, it's up there, right? Maria Ramos. I think it's,
Okay, just give me a moment.
sure.
Joe Ramos?
Yes.
All right, where's Mr. Ramos?
Oh, Mr. Ramos. Sounded like Ross.
And so you said he's competent and the hearing has been held?
Yes, Your Honor, just yesterday.
All right. Then I am going to put you down for a plea deadline date. How much time are you asking?
30 to 45 days.
All right, Ms. Ferguson, a 30-day reset for plea deadline date. All right,
I
do you like to?
I think I'm out that day.
Okay.
Yes, I'm out on the 10th. 14th I can do.
All right, July 14th is your plea deadline date. On that date, you need to let the court know whether you've reached an agreement. If you have not reached an agreement, your plea deadline date will expire and the court will set you for a jury trial and the court will not consider any plea bargain agreements without good cause. Otherwise, you'll have to plead open to the court. Do you understand? All right, thank you. Once you sign the reset form, you're excused.
Thank you, guys.
All right. And you're here for, oh, could you please bring him back? All right, if you'll have a seat. And what's your client's name?
Jalen Ross, Judge.
All right, could I have his file, please?
Who is that? Jalen Ross. Jalen Ross.
And I see it's raining.
Oh, yeah, I got poured from, I got wet from head to toe. But I was having like a lot of problems, like last night, my power kept going out. It went out like 5 times. And then like this morning, I couldn't hear you. So I apologize, but
No problem.
I did confer with the state and we
The motions that she just filed this morning,
Yeah.
we haven't had.
Yes. Yes. All right, thank you. All right. And you're here for, oh, could you please bring him back? All right, if you'll have a seat. And what's your client's name?
Jalen Ross, Judge.
All right, could I have his file, please?
Who is that? Jalen Ross. Jalen Ross.
And I see it's raining.
Oh, yeah, I got poured from, I got wet from head to toe. But I was having like a lot of problems, like last night, my power kept going out. It went out like 5 times. And then like this morning, I couldn't hear you. So I apologize, but
No problem.
I did confer with the state and we
The The motions that she just filed this morning, we haven't had proper time to review them, and we'll give this at least 3 days before those motions are heard.
Oh, we can go for it. It's a motion to
No,
reconsider.
I wanted to start to talk about it in chambers if that's possible.
All right, so here's the thing. Once I have motions to reconsider, I always tell people. So I'm not gonna reconsider his sentence. Unless there's some evidence where he should have a motion for new trial.
All right,
Not
that's
gonna-
correct, Judge. So I filed a motion to withdraw the plea, and I've also filed a verified motion to recuse.
All right, I don't have the motion to withdraw before me,
I have copies. So
and
that's
you
why I
want to
wanted-
withdraw.
No, I'm not asking to withdraw as his lawyer. I'm asking for the court to be recused.
All right, well, what I can tell you is I'm not reconsidering any sentencing. And if you want a motion to recuse, another judge will have to hear that.
That's correct, Judge. So I'm asking that it be, and I know the state's asking for a few more days to properly.
Oh, there's
prepare.
nothing for me to do on the case once you file that. All right, thank you.
All right, thank you, Judge.
You're welcome.
Hmm.
All right, the court is calling 2025 CR 005028 State versus Kaya Medellin. Am I pronouncing your first name correctly?
Yes, ma'am.
All right, could I have parties announced for the record?
Andrew Harris says state.
Donald Wilson for the defense.
And are you Kaya Medellin?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, I have.
Court will find that the state is in compliance with discovery. Did you, Ms. Medellin, did you review the application for deferred adjudication?
Yes, ma'am.
Did you understand it and sign it? Okay. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, I do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Okay. Did you understand you're charged with graffiti with a loss of $2,500 up to $30,000 as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, I believe so.
Ms. Medellin, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that the defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, there's a $0 fine. State recommends deferred adjudication. There's to be restitution of $5,200, and there is to be payable to shops at the River Center, the $5,200. Did you understand that to be the plea?
Yes.
Defense?
Yes,
State?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
no, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 3 years. There be no contact with the shops at the River Center in beautiful Aurora, a life skills course, a TAP evaluation, and community service hours. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Be considered.
continuing to.
No objection, Your
All
Honor.
right, State, you may be excused. Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there sufficient evidence to find you guilty. The court will defer finding the guilt as you apply for deferred adjudication. Are we proceeding with sentencing?
Yes, Your Honor.
All right. When are you going to be able to pay off this $5,200? Are you employed?
Yes, sir.
What do you do?
I work at Wendy's.
All right, so when are you going to pay off this $5,200?
I can pay it all. In 4 months.
All right, if you're drug tested today, what are the results going to be? What are you going to be positive for? All right, so you're going to have to, how old are you? 18. You're going to have to put your life on track. Why were you spray painting stairwells?
I have.
All right, so let me just tell you what's going to end up happening. I'm going to postpone your sentencing. Do you live at home with your parents? All right, are they charging you anything to live with them? So what do you spend your money on?
Anything for myself,
Like what?
essentials, wash, like body wash.
All right, so how much do you make a month?
1,600.
All right, so what I'm going to do is this is being recalled for the end of July. And you need to bring in at least $400 to be paid towards this restitution. Do you understand? All right, Ms. Ferguson, give me a sentencing date. The end of July. Counsel, you're available July 31st?
I believe so, Your Honor.
All right, so you'll need to have paid towards your restitution. Do you understand?
Yes.
And probation, can we have a TAP evaluation started on her out of custody? All right, once you sign the reset form, you're excused. All right, thank you. Who's here on Angel Rhonda?
I am there. Yes.
All right, today is his plea deadline date.
That's correct, Judge. Client discussed it with my client. He's rejecting the offer and we're requesting a trial date.
All right, and is this family violence or criminal trial division?
It's with family violence.
All right, if you'll confer with Ms. Ferguson on a jury trial date.
Okay.
All right, state, if y'all can confer on a jury trial date.
Yeah.
And how long do y'all expect this trial to last?
3 or 4 days, I would think, Judge.
All right, Norma, I need a jury trial date, 3 or 4 days.
Can you like it?
I need to check that real quick.
Okay.
Excuse me. That actually does not work for me.
Okay.
I don't know what else is next, but
All right, Norma, they need a due date.
okay,
All right, what date?
July 29th, Judge.
All right, make sure that I have an acknowledgement of discovery. Mr. Rhonda, your plea deadline date has expired. The court will not consider any plea bargain agreements in this case without good cause. Otherwise, you have to plead open to the court. Do you understand?
Yes.
All right, thank you. Once you sign the reset form, you're excused. All right, who's here on Freddie Gonzalez? For it.
Make sure you speak to other.
All right, on this case, where are we on discovery?
Judge, on the two indicted cases, it appears that both cases do have complete discovery as far as we can tell at this moment. That both cases are related to each other. Documents that are alleged are in our discovery packet.
All right, and State, were you able to tender an offer or no?
Judge, I was not, I believe that the discovery is complete on the two indicted cases that he has, but the defendant does have, about 9, unindicted cases that are awaiting indictment, and so, I'm asking the court for more time to obtain discovery and at least some of those cases so that I could, tender a global offer to defense for consideration.
All right, is 60 days enough time? All right, Ms. Ferguson, I need a 60-day reset.
Monday, August 11th.
All right, August 11th. Once you sign the reset form, you're excused. Thank you.
Thank you, Judge.
You can put it as discovery, but the state is going to tender an offer. Okay, thank you. All right, who is here on Fabian Rodriguez? Are you ready to proceed on the motion to revoke?
No, Your Honor, we're asking for a reset. My client has 2 cases pending and there is a recommendation from probation and from the prosecution concerning Sarif, and they won't take him with 2 cases pending. So we wanted to take care of those 2 cases. There's a misdemeanor DWI, and I'm not representing him, but that's set for July 17, misdemeanor code. I think
Okay.
it's County Court Law 15.
All right, this has previously been set for a contested hearing. This is what the court is going to do. Norma, set this for a contested hearing for the week of July 21st.
We can do the 21st.
All right.
Thank you, Judge.
And I'm sorry, when did you say again the misdemeanor case is set?
July 17, Judge.
All
So
right.
we're good. We'll have time.
All right, thank you.
Thank you.
All right, who's here on Willie Fields? All right, what's your client?
He's in federal custody, Your Honor. I'm just checking back in to give you staff support.
All right, so what is this setting for federal custody? Do you have a?
Federal custody, yes, the assistant federal public defender that is working with him is been out of the office this week, but he is, the next setting in the system is for July the 22nd.
All right, Norma, if I can get a date for the second week in August, please.
Thank you, Your Honor.
You're welcome.
August 11th.
All right, we'll see you back on August 11th.
Ma'am.
Thank you. Who's here on Tavon Palmer? All right, Vashon. Kelsey's going to be reset because the attorney is with their son.
She's here.
Miss Chelsea, if you come down. Hello. Hi, we're going to recall your case for June 23rd. Your attorney is on vacation. Okay, all right, we'll see you then. Thank you. All right, Mr. Advigan Liao. We're going to recall your case for the 23rd. Your attorney is actually on vacation.
Okay, yes.
All right, once you sign the reset form, you'll be excused.
June 23rd?
Yes.
Okay, thank you so much.
Good morning.
Good morning.
Coach. I'm sorry about that.
Oh, no problem. Who is your client?
It is Mr. Palmer.
All right, Mr. Palmer, come forward. Hello. All right, let me check Odyssey. All right, so in this case, where are we on discovery?
All right, I was just informed this one, this is actually was signed as CT, but it should be a family violence case.
Okay.
Additionally, I was informed by counsel that she is missing some discovery things, so I'll work at getting her what she needs. But we also need time to touch the victim, and this has not been done yet, so once that's all done, I'll be in a better position to work out the agreement with.
All right, Ms. Ferguson, recall this in 40 days for discovery.
Judge, is there any way we can recall this case to next week? What we're really missing is just paper discovery, and I don't want to delay this any further since this is our second setting.
Sure.
And I talked to the state and they said a week would be fine.
All right, Ms. Ferguson, if you recall this for June 16th. Okay,
Thank you, Judge.
Monday, Thursday.
Can we do Tuesday? I'm out of town on Thursday.
we can do Tuesday.
Tuesday.
Thursday is a holiday.
Oh, that's true.
Thursday,
Juneteenth.
That's right. Yes. I'm sorry.
All right. Yes, the 17th.
Thank you, Judge.
All right, thank you. Once you sign the reset form, you're excused. Thank you for dressing appropriately for court. All right, the court is calling 2024 CR 012293, State versus Summer Mesquita. Can I have parties announced?
Andrew Priest for the defense.
And are you Summer Mesquita?
Yes.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Are there any applications in this case?
No, Your Honor.
All right, Ms. Moscata, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
To proceed on the lesser included offense of attempted possession of a controlled substance, PG2, less than 1.
We have no objection, Your Honor.
All right, did you understand, I'm sorry, did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
The state is proceeding on the lesser included offense of attempted possession of a controlled substance, penalty group 2, less than 1 gram, as a class A misdemeanor. Range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you enter a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes. Ma'am.
All right, off the record. And all of this, she's just signing her name, Summer.
I told her to sign it as she normally would sign documents, Judge, and she expressed to me that that was her signature.
All right, you need to sign your full name.
Yes.
Thank you. Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I believe she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe she was.
Ms. Mosqueda, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on the lesser included offense of attempted possession of a controlled substance, penalty group 2, less than 1 gram. They're asking that your punishment be assessed at 10 days in the Bexar County Jail and a $500 fine, and there are no applications. Did you understand that to be the plea? Defense?
Yes, Judge, and it was also my understanding that it was the belief of the parties that this judgment would be satisfied.
All right. And state, did you understand that to be the plea?
She does have credit for the 10 days.
Okay. All right. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
Not at this time, Judge.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest? State any evidence?
State offer states one in attachment.
I've reviewed that with my client. We have no objection.
All right. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Judge, we would just ask that the court follow the plea bargain. My client is young. I believe she has a child. Her hope is the court would follow this plea bargain and she would just be able to put this behind her and get on with her life.
All right, and states you wanted to explain about the 10 days?
Judge, so the reason that the plea agreement that we is as you've seen in the review of the stipulations, this was a multi-offense arrest where she was also arrested for theft, for defensive purposes. They decided to handle them separately. She was placed on deferred adjudication for the theft and completed it satisfactorily enough to where the misdemeanor court did term her unsat. And so taking that into consideration, that's the reason that we reached an agreement.
All right, the court then is going to find you guilty, sentence you to 10 days in the Bragg County Jail, give you credit for any time served. There's a $500 fine, time and money to run concurrent. There's to be no contact with target, and the court will find that the judgment is satisfied.
Thank you, Judge.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, we can go off the record. How old is your child? How old is your child?
It's Judge.
2. All right. So do you have any family support with him?
Yes, ma'am.
All right. So here's the thing, my understanding, you're done with all of your cases, right? So you have to remember that your child is 100% dependent upon you. I understand if you're a single parent by yourself, things can get stressful. If things get stressful, if an issue comes up and you don't know what to do and you don't have anybody to talk to, if I'm still here, you can come back here and I will find somebody for you to talk to, okay? All right, good luck to you.
Thank you, Judge. May I be excused?
Yes. All right, who's here on Isaiah story? Court is calling 2025 CR 00582, State versus Isaiah story. Can I have parties announced?
Rick Pena for the state of Texas.
Howdy, Joe Stenberg, representing the defendant Isaiah Story.
All right, is there any applications in this case?
Any what?
Applications for deferred or?
No,
Okay,
is it to do?
all right, and are you Mr. Story?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, ma'am.
Court will find that the state is in compliance with discovery. Mr. Story, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
Yes, we are, Your Honor.
Mr. Story, did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand your charge with sexual assault as a second-degree felony? Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine.
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He had.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Story, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's an 8-year sentence, a $1,500 fine. There are no applications. There's to be Chapter 62 compliance and no contact with the complainant. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes.
State?
As the plea, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
Not really. There was a request for bond, but never mind.
All right, then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
This time, state the evidence, states exhibit one with all attachments.
And state, have you spoken to the complainant?
Yes, we have, Your Honor.
All right, thank you. You may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes.
Anything you wish to say on behalf of your client?
Other than the fact that, keep in mind, he was 17 at the time. Thinking with what I call the wrong head.
Okay. All right, the court will find you guilty. The court will sentence you. Just one moment. Because you're saying he was 17 at the
Yes.
time, but in the police report, it says that they are more than 3 years apart, but
Well, the
joint
girl
collection.
was 14.
Well, according to, just one second, we're going to go off the record for a moment. This is what the court is going to do. The court is going to find you guilty. The court is going to sentence you to 6 years in the prison, give you credit for any time served. There's a $1,500 fine, time and money to run concurrent. There's going to be Chapter 62 registration and no contact with the complainant and no contact with minors. And let me just tell you the reason why I did the 6 years. Because I realize how close in age you both are. All right, and that you're 17, okay? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you're going to need to speak to an attorney, and you're going to have to register for the rest of your life. Do you understand?
Yes.
All right, good luck to you.
Can I put on the record, I take back some of the things I said about him.
You're always a hoot.
Thank you very much, Your Honor.
You're welcome.
May I be excused?
Yes.
Okay. Wait.
And I guess this is for one case. Court is calling 2024 CR 4295 State versus Luis Beltran. Can I have parties approach and announce for the record?
Arlene Gay is the defendant.
All right, and are you Mr. Beltran?
Yes, Your Honor.
All right, in defense, you said you've adopted his motions?
Yes, Your Honor.
All right, so the first motion is a motion for a special appearance under the authority of Texas Rules of Civil Procedure 120A for the divine purpose of objecting to the de facto district court's abstract subject matter jurisdiction, non-ex parte third-party waivers allowed. So let's address that motion.
Yes, Your Honor. My client's position is that that there is a defect in the abstract subject matter jurisdiction, that he has been brought into this improperly because the state would be the plaintiff, and they brought him in and are litigating that, and that there's a jurisdictional issue
that the court does not have in persona or subject matter jurisdiction.
All right, is there a response, Sate?
Judge, as a criminal district court, the court does have jurisdiction to preside over any matters. The defendant has been charged by indictment with the offense of aggravated robbery, and that occurred in Dare County, Texas, and so the court retains jurisdiction over those proceedings.
All right, so Mr. Beltran, anytime that there is a criminal case that's deemed by the penal code to be a felony, then that comes to a felony criminal court. All right. And then the next question becomes whether or not a grand jury has been given evidence. You've been indicted, so they've been presented with information, right? And if it's alleged that the incident occurred in Bexar County and it's a felony, then I would have jurisdiction over the case. So if for some reason this was a case that is alleged to happen in another county, let's say it's Hayes County or Harris County, then I wouldn't have any jurisdiction over it. Do you understand? All right. So with this case, I'm not taking any of it to be true because I have to wait till evidence is presented to me. But looking on the face of in the indictment, and I'm sure your attorney will tell you, an indictment is not evidence of guilt. It's just the means whereby a person is held over for trial, right? And so when a grand jury indicts a case, they're just saying there's enough evidence to hold you over for trial. They're not saying it's evidence beyond a reasonable doubt. And when information is taken to the grand jury or evidence, police reports or whatever it may be, and it has to be allegations that it happened in Bexar County, and it has to be allegations that it's a felony. Now, if this were not alleged to be a felony, then it wouldn't be in this court. Even though it would be a criminal case, it would be sent to a misdemeanor court maybe, or perhaps even a municipal court. But because aggravated robbery, according to the penal code, is a felony, it's supposed to be in a felony court. And then if they're saying it happened in Bexar County, then it would come to a felony district court, state district court that's in Bexar County. And that's where we are. You understand? Is there anything you not understand about my ruling on that? All right, thank you. And then we have,
Excuse me, did the court take judicial notice of the indictment in this case?
yes,
Make its ruling, okay.
yes.
The
next we have new discovery of ex parte corpus trust fraud upon the court that conceals the facts that the charging instrument lacks subject matter controversy. No injury in fact exists.
Your Honor, I believe what my client meant by that is just kind of coupled with the first paragraph that the court his position was the court didn't have jurisdiction. The court just ruled that they did. That then the indictment would not be valid in this case. So I think that's what the client is trying to say.
All right.
Did I get that right?
Yes.
Okay.
All right. So State, you want to address the issue and if I'm interpreting this incorrectly, let me know, okay? So you are saying that the offense, that there is no subject matter jurisdiction because there's no injury by any party?
Yeah.
All right. So if you can address that.
Your Honor, this case was presented to a grand jury that was duly impaneled. They indicted the case. They returned a true bill of indictment. The indictment does comply with the penal code and the code of criminal procedure, which governs in this case. And it does allege the requisite elements for the aggravated robbery. And so it's a threat by using a deadly weapon. And so that is the harm. The crime was committed against the peace and dignity of the state, and there is an alleged complainant.
All right. So Mr. Beltran, do you understand with the charge of an aggravated robbery case, sometimes it's alleged that a person maybe pulled a knife on somebody and said, give me your money, right? I don't know any of the facts about your case. The only thing I can do is look at the indictment, right? And then sometimes it's alleged that somebody pointed a gun at somebody and said, give me your money. The way indictments work is if it is a crime in the penal code, and there's a list in the penal code of all the crimes, and aggravated robbery is one of those crimes that's listed in the penal code, and it sets out what the elements are of that. Now, you're saying that there was no injury in fact exists. The only thing the state has to do is prove the elements that are in the indictment, and the indictment has to show the offense that is in the penal code. You understand? So, do you understand? You gonna have any questions about the court's ruling? All right, if there's something you don't understand, let me know, all right? And I understand that sometimes when people have been to law school, like for example, I haven't really worked on cars. So there's a little stuff I can tell you about being a mechanic, but I really don't know the ins and out of every vehicle. You understand? All right, so number 3, defendant is erroneously charged with an abstract offense. C, I don't know, I can't read that word. Something taxation. District court is criminally attempting to receive an unauthorized, colorable, no fault immunity third-party benefit in violation of the 7th Amendment. All right, do you want to address that, counsel?
Yes, I believe my client, I think it just goes back to, being a third party brought in here without, abstract subject matter jurisdiction. And, the fact that he was brought into this case. I believe that's it. Is that it? Okay.
All right, State, do you want to respond?
Judge reverting, I guess, the 7th Amendment applying in the case, or, okay,
Yes.
that is for civil suits. We are in a criminal court, and so I would argue that that does not apply here.
Mhm. All right, so the 7th Amendment applies to jury trials that you're entitled to, and that is in federal civil cases. Here, you do have a right to a jury trial if you want a jury trial, and if you want a jury trial, I'm going to make sure that you have a jury trial, okay? And then the other issue, let me see. I don't understand when you say, explain it to me, you're saying district court is criminally attempting to receive an unauthorized, colorable, no fault immunity? What do you mean by that? Because what I can tell you is I don't receive anything related to these cases. Of course, as a judge, I'm paid a salary for the work that I do, but I don't receive any funding or extra funding based upon how I resolve cases. Do you understand? Do you have any question about that?
No, ma'am.
All right, so then the other one is dishonest services that rises to constitutional tort and national security concerns, communist activity detected in violation of Title 50 USCS 841. This court now under federal questioning under Title 28 USC 1331, light of new evidence investigation hypothetical claims. All right, defense.
I'm not sure what my client means by that. I'm gonna ask him to explain it.
All right, if you could explain that to me, Mr. Beltran.
I guess what I'm trying to say there, Your Honor, is how the state of Texas is plaintiff. And they're the ones that are pursuing into prosecuting me, which is they're one of my third party.
Okay,
And I'm not. I don't. Third party, I'm not sure how that works. I know
Okay.
how civil suits, and I know it's criminal law, but I know that. I mean, how can I cross-examine the state of Texas? How can I?
So let me explain something to you. Whenever you see cases on the criminal side, it's not individuals versus individual. Usually when you're on the civil side, if it's a marriage, it's individual. If it's civil. All right, here, the reason why it's the state of Texas is because in criminal court, it's not you versus the complainant. Whoever the complainant is in this case that you're accused of committing aggravated robbery against, yes, it's alleged to have happened that you committed an aggravated robbery against them. But the state of Texas, the way we were taught in law school, the state of Texas takes offense, right? Because whenever an offense is committed against a citizen, it's the offense against the citizen, but it's also the offense against the state of Texas. So in cases such as these, the state necessarily is not the complainant. They're just bringing the suit or the case because the state of Texas is offended that an offense is alleged to have been committed within the state of Texas, within the county of Bear. So that's why the state of Texas is listed and not the complainant. Do you understand?
Yes, I understand that. And so how do I cross-examine the state of Texas?
The state of Texas, you don't cross-examine them. The persons you would cross-examine would be any witnesses the state of Texas would call to try to prove that you've committed an offense against the sensibilities of the state of Texas. So, for example, for an aggravated robbery, they'll need to call somebody to prove that it happened in Bear County. They'll need to call somebody to prove that it happened on or about whatever date it is. If there's a weapon used, they'll need to call somebody to prove that a weapon was used. And they may need to call a complainant to say, hey, I'm the person in your indictment. You understand? All right. Do you have any questions or any confusion? All right.
May I ask my client a question before you go on to next? Are there any other things in here? Because some of it repeats itself. Were those the main points?
Other than anything.
Or is there anything else in your motion that are different that we need to bring to the court's attention that would be different?
All right. So then with regards to that motion that's combined from page 1 to page 6, then the ex parte relief requested will be denied. Now, by denying that, that doesn't mean that if there's a jury trial, your attorney still will not have the opportunity to question whatever witnesses the state calls, okay? So that will be denied.
There is it appears to me that there was like 3 separate documents stapled together. Is that the way it was received?
Yes.
There is the next one, which is exhausting administrative relief. My client is not wanting to have that heard, right? It deals with ineffective assistance of counsel. Right, Mr. Beltran, that's not to be heard right now?
Okay, and let me explain something to you. I understand that's not to be heard right now, but what I can tell you is attorneys who are appointed to represent people, those are attorneys who are on the wheel for appointments, right? And if this is a first-degree felony, just from the face of what I'm looking at, and if Ms. Gay wasn't qualified according to the qualifications to be on the wheel for first-degree felonies, she would not have been appointed to represent you. Do you understand? And Ms. Gay, are you on the first-degree will?
Yes, I am.
All right.
So the next document is entitled Court Constitutional Notice. And that addresses antitrust violations, fraud upon the court, actions of the state bar.
All right, do you want to take these one at a time, counsel?
I guess so, Your Honor.
All right, the first is new discovery of antitrust violation lies brought upon the court. Elected state bar officials, seditious organization are conspiring to fraudulently conceal the ultimate fact, Sixth Amendment misconduct, that the state bar of Texas lacks capacity to prosecute a natural person. It is an improper plaintiff. All right, so with that, I can tell you, the State Bar of Texas is not prosecuting you. The State Bar of Texas is more of an affiliation that attorneys are required to belong to. And we actually have to pay state bar dues every year. And when that comes around every year, everybody's like, oh my gosh, state bar dues.
Student.
Yes. So, the state bar is not participating in this trial. Now, I can tell you as an attorney, your attorney as an attorney, and the state as an attorney, anyone who's licensed in Texas, they're required to be a member of the State Bar of Texas, and they have to pay dues to the State Bar of Texas. I think it's $265. It may have gone up. All right, so they're not going to be trying you. All right, the next one is state bars, virtually gathered evidence, video, police reports, third party. Again, what I can tell you about that is the state bar hasn't gathered any evidence. State.
I think I just put, I'm sorry, Your Honor.
Yes.
I think I just put that as.
All right, so do you want that heard or no? All right, and then the next one is, so to permanently prevent a false state bar, anything with regards to the state bar, do you still want that heard or no? It says objects to Texas State Bar ex parte matter waivers and fictional double jeopardy defective jurisdiction. Do you want that heard?
Yes.
All right. Defense?
My client believes that, again, that the court does not have jurisdiction, that he is concerned about his waiver of his constitutional rights. Some of this deals with what happens at trial, like hearsay evidence being admissible, being admitted wrongfully, and that he still believes he's a third party, and that there's abstract jurisdiction, and that the court doesn't have the power, I'm guessing, to rule on evidentiary issues such as 901. And that, in other words, probable cause is third party fabricated, then secretly planted and dressed up to appear that it has merit, but it does not. So he is talking about one jurisdiction and also trying to state his right to object to evidence.
All right, State, do you want to address that?
Regarding this collection of evidence, I'm not sure.
Oh, no. So, let's address double jeopardy. Double jeopardy, defective jurisdiction. So double jeopardy, if you have not been previously tried for this same offense before, that's what double jeopardy is. Basically, in a nutshell, there are certain exceptions to that. But when you mention double jeopardy is you've been tried for something before and you were found not guilty, right? And now the state is trying to try you for the same thing, even though you were previously found not guilty of it. Or either you had something that was dismissed with prejudice and they're coming back and trying to try you for that same offense. Do you understand?
Yes, ma'am.
State, has he been tried before for this same offense?
No, Judge, there has been no actions on the indictment or the indictments that are pending against him. And as far as I know, he's not been charged by any other jurisdiction regarding this.
And there has never been anything pre-indictment that was dismissed with prejudice with regards to these cases?
No, Judge.
All right. Does that address that issue for you?
Yes, ma'am.
All right, then the next one, deceitful corporate veil and trumped up judiciary immunity is fatally pierced. I do not forfeit my privileges and immunities under the Fourth and 14th Amendment. What I can tell you is during a jury trial, when the state calls their witnesses, your attorney will have a chance to cross-examine those witnesses. The rules of evidence do apply. If she finds that there is some question that is objectionable and should not be answered, then she will stand up, make an objection. Normally, the objections may be hearsay, entering the province of the jury, assuming facts not in evidence. It could be relevancy. It could be 404B. It could be any of a number of objections that she can make. Once she makes those objections, I will make a ruling, and my ruling will decide whether or not the witness can answer that question and whether or not the jury can consider it. Do you understand?
Yes, Your Honor.
All right, does that address that issue?
Yes, Your Honor.
I think the other issues deal on the second page, deal with the State Bar, and I think the courts addressed that.
Okay.
The other one is gross advertising negligence of the DA's office.
Okay.
And defendant being sued,
Or who's being sued?
the defendant.
All right. So, sir, there are different type of suits. There are civil suits. So technically somebody can be sued civilly for something. Sometimes with criminal cases, people will say, oh, it's a suit. Technically, it is sort of a suit, but it's again, the state of Texas versus whoever the defendant is. You understand?
Yes, Your Honor.
All right. Do you have any questions about anything else? Okay. And then the next page, page 6, it has postscript. Is that something in there that needs to be addressed? I think it says here, it has to do with cross-examination. And then he say the plaintiff is in harmless artificial corporation. Are you talking about yourself or the state of Texas? Okay. All right. So whether or not it's a fishing expedition or a corporate entrapment or a Ponzi scheme, that'll be something that will be decided during the jury trial, okay?
Yes, ma'am.
All right. All right, is there any other motion that needs to be heard?
Anything else? Any other jurisdictional arguments that raised that we have not talked about and the judge has already ruled? Anything other than
No.
All right, is there anything that you don't understand about the jury trial process? All right, so I will still give you a choice. If you want a jury trial, you can have a jury trial. If you want a bench trial, if the state agrees to the bench trial, then we can have a bench trial. As I've told you before, if the state presents evidence that proves you guilty beyond a reasonable doubt, that means each and every element, I'll find you guilty. If they don't, I'm going to find you not guilty. You understand?
Yes, sir.
All right, so if you still want a jury trial, you're, Norma, is he already scheduled for jury trial?
Not scheduled for yesterday, Judge.
All right, so, counsel, you're still requesting a jury trial? All right, Norma, if you can put them on the, jury trial, please, and Ms. Galloway, if you confer with the defense on a jury trial date, so they're gonna get a jury trial date, okay?
Thank you, Your Honor.
Oh, you're welcome. And who's the attorney on Edward Rodriguez?
Here, Judge.
Okay. All right, court is calling 2025 CR 002041 State versus Edward Rodriguez. Could I have parties announced?
Megan Galloway for the state.
Adam Lohead for the defendant, Your Honor.
And are you Mr. Rodriguez? And there are no applications?
No, Your Honor, it's a straight term.
All right. Counsel, you received all discovery. Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Rodriguez, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, I did, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Rodriguez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? All right, you're charged with manufacturing and delivery of controlled substance penalty group 1, 4 to 200 grams as a first-degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Rodriguez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promise you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, sir.
Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 5 years in the prison. There's a $2,000 fine, no applications, and this will run concurrent with 2024 CR 2941. Did you understand that to be the plea? Defense, is that the plea?
It is, Judge.
State, is that the plea?
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
We have no objections, Your Honor.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in both places? I'm sorry, in all of the places. Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Judge. We don't need a PSI.
Anything you wish to say on behalf of your client?
Your Honor, just that he acknowledges he made a mistake. He's here owning up to it and taking responsibility, Judge.
All right, the court will find you guilty, sentence you to 5 years in the prison, give you credit for any time served. There's a $2,000 fine, time and money to run concurrent, and this will run concurrent with 2024 CR 2941. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we'll move on to 2024 CR 2941. Are you the same Edward Rodriguez who's placed on deferred adjudication in 2024 CR 2941 for the offense of injury to a disabled person with intent bodily injury on May 2nd, 2024 for a period of 6 years? All right, and did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney and understand it? All right, state.
Violation of condition number 1 on or about the 21st day of November 2024 in Bexar County, Texas. The defendant, Edward Adam Rodriguez, committed the offense of possession of a controlled substance in violation of condition number 1.
How do you plead to that? True or not true?
True.
State.
You waive and abandon the remainders, Your Honor.
Any objections?
Objections, Judge.
All right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison? and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number one? Court would find violation of condition number one true. Is there a proposed agreement?
There is, Your Honor, it is to revoke the defendant's community supervision, adjudicate him guilty, and sentence him to 5 years in the prison
That is our understanding, Your Honor.
and run concurrent with
Yes.
the case that we just pled on, Your Honor.
Oh. All right, probation, has he done anything on probation? You want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record. All right, why were you not successful on probation?
I was actually did my classes, AA and A. Had my probation officer submit copies. And I also was the day I got arrested for my new charges. I was gonna graduate my parenting class. So, I made the 2 payments. I just got a job 2 months prior to the arrest, and yeah, I did all the classes I had. I was just about to graduate my parenting, and
I guess when probation knocked on your door for a scheduled field visit, that was shocking, wasn't it? See, and you know what? People always wonder why field visits, because you know what? You really don't know if someone's doing well until you get a chance to see them in their homes or sit down and have a meal with them. All right, the court is going to follow your agreement. Are you waiving your right to appeal?
Yes.
The court is going to follow your agreement, find you guilty, revoke, sentence you to 5 years in the prison. This is run concurrent with 2025 CR 002041. There's to be no contact with David Rodriguez. And I'll suggest the therapeutic community. All right, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, just one moment. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. You need to start asking yourself, what you want to do with the rest of your life, because what's going to end up happening is you're going to wake up and find that you spent the majority of your life in somebody's prison or jail. If you don't change, that's what's going to end up happening. If you continue on the path that you're on, people who sell drugs, one of two things going to end up happening. One, you may make some money, but at the end of the day, you're not going to know where it went. Or somebody's going to try to rob you to take your drugs and your money. Or somebody's going to be upset with you because you let somebody rob you and take the drugs and they want their money. Do you understand? Do better. Good luck to you. Oh, thank you. God bless you too.
Thank you, Your Honor. May I be excused?
Yes.
Thank you, Judge.
Judge, and so trial date will be July 22nd.
All right, July 22nd. All right, we'll see you all for jury trial then. We'll see on Rogelio Alfonso Elizondo. If they can come up.
Just so the court's aware, I was out of town this morning. I let the court know, so
Oh, problem.
that's why I was late.
All right, so today is plea deadline date. Does he want a jury trial? What are we doing?
So I conferred with the state on this. Last setting, I filed a motion of substitute, which was granted.
Mhm.
I had an opportunity to review the discovery, Your Honor, and noticed that I was missing the dash cam for the arresting officer, the person that actually stopped him. I let the ADAs know that, and they've requested that via email. I'd like the court, if possible, to give me 2 weeks so that they can get that discovery. I don't think it's gonna take that long, but so I can review it before we proceed.
All right, Norma. I need a 2-week reset. And it's a plea deadline date.
June 26th.
All right, June 26th.
Thank you, Judge.
All right, once you sign the reset form, your excuse. You're welcome. Rebecca Davis. Hello.
Hi.
All right, so have you conferred with the state?
Yes, I have, and they are not opposed to the occupational license. She is currently complying with her conditions, which is to have the interlock device. So she has that on her vehicle.
Okay, we'll need to go on the record.
Okay.
All right. Could I have someone from the state? The court is calling 2025 CR 003154, which is the trial court cause number, and 2025 CI 11673, which is the civil request for the occupational driver's license. Could I have parties announced for the record?
Jason Garahan for the state, Your Honor.
Arlene Kay from Miss Davis.
And are you Miss Davis? All right, so there's a request for an occupational license. And you may proceed.
Your Honor, my client filed this pro se, and I found out that I was appointed to assist her today. So I have gone over the document. We talked about it. She does have the interlock device on her vehicle. This is an essential need. She is starting a job on the 26th of this month. She is living in the SOBA facility, rehabilitation facility. They do allow vehicles. And, you know, besides the interlock device, she is tested for drugs and alcohol routinely while she is there. She wants to start her job. Also, she will need to drive to get to not only in the future doctor's appointments, but also appointments related to her probation. And then we have the household going to HEB, getting gas, things like that, that she's asking to go to. I believe that the statute allows to drive up to 12 hours a day. I think she put from 6 a.m. to 6 p.m. now.
Well, what I can tell you all, and let's go off the record. Okay, this is what I need that's not in this document. I don't have any proof that she has insurance. So if we can have that in the document.
She has her SR 22 with her.
So if you want to make copies of that,
Okay.
or is that your copy?
Yeah.
I also have my interlock, my driver's record.
That's what all needs to be here. So
All these are copies, so and my treatment, presence of treatment letter and my actual finding.
all right, state, have you had a chance to review those?
I believe my co-counsel has,
Okay.
and we have no objection, Your Honor.
All right, so that's what I would need. And also there is a section in here that they want you to check off the times that she would need to be driving. So if y'all could go through that document or make a copy of the document, because technically it's filed. And if you all can make a copy of the document and put in what you need to put in.
Okay. And Your Honor, do you want these attached to
Yes.
it? So I can get it and just put first amended
Yes.
and attach proof, and then
So I'll need the proof of ignition interlock, the proof of insurance, and she needs to put in what time she's asking to be allowed to drive.
I'll talk to her about that, because 6 to 6 sometimes jobs
Okay.
may be a little difficult.
All right, so once you all do that, you can come back.
Okay, great.
Thank you. Thank you.
Your Honor.
Yes.
She did not include it in order.
She did not do what?
Include an order, because the form didn't have an order. And she didn't know what an order is.
Okay.
So whatever we do today, I'm gonna have to go back to my office.
Well, I tell you what, if you'll type it up, but I am going to be gone next week at a CLE that I have to speak at, but I'll be here tomorrow.
Yeah, I can type it up and bring it tomorrow.
Okay.
Okay.
All right, just bring it and I'll take care of it. Thank you, and continue with the good work, okay?
Yes, ma'am.
All right. Who's here on Omar Herrera?
Right here, Judge.
And then after Omar Herrera, oh, there are two. And Vashawn, this is an application. All right, the court is calling 2025 CR 0033736 and 2025 CR 0038886 State versus Omar Herrera. Can I have parties announced?
Albert Chidas for Mr. Herrera.
And are you Mr. Herrera?
Yes.
All right, we have an interpreter here today. If you could raise your right hand for me, please. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
Yes.
All right, you can lower your hand if you'll state your name for the record, please.
Pamela Payan. Payan.
Mr. Herrera, all of these documents are in English. Were those documents explained to you in Spanish?
Yes.
And counsel, do you speak Spanish?
I do, Your Honor.
And do you speak it fluently?
Yes, I did.
And were you able to explain these documents to your client in Spanish?
Yes, I was, Judge.
All right. Counsel, have you received all discovery and did you review it with your client?
I did.
And
And I
each
did.
cause number?
I did and I did.
Perfect. In each cause number, the court will find that the state is in compliance with discovery. Mr. Herrera, in each cause number, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes.
In each cause number, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, in each cause number, do you waive the reading of the indictment?
We do, Your Honor.
State, in each cause number, are you proceeding on the indictment as presented?
Yes, Judge.
Mr. Herrera, in each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
In each cause number, you're charged with unauthorized use of a vehicle. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
All right, off the record for a moment. Counsel, on this one, he hasn't checked the box. All right, we're back on the record. And each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in each of these cause numbers?
Yes.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, and yes.
Mr. Herrera, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
No.
Anyone promised you anything other than the plea?
No.
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
All right, you have to wait for her to finish translating. Either we're going to use the translator or we're not. Do you understand?
Yes.
Do you want to use the translator?
Yes.
All right, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargains in each of these cause numbers with your attorney? Did you understand it?
Yes.
According to the plea bargaining agreement, your punishment is to be assessed at 2 years in the state jail facility. The state is recommending community supervision. The cause numbers were run concurrently, and there's to be restitution, if any, to the complainants in each cause number. Did you understand that to be your plea?
Yes.
Defense, is that the plea?
It is, Your Honor.
State?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Sí.
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Sí.
Yes.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 3 years. Did you understand that was a recommendation from the state and the court does not have to follow those recommendations?
Sí.
Yes.
Then in cause number 2025 CR 0033736, how do you plead? Guilty, not guilty, or no contest?
No me pongo.
No contest.
And cause number 2025 CR 0038886, how do you plead? Guilty, not guilty, or no contest?
No me pongo.
No contest.
State any evidence to support the defendant's plea?
In each case contained in Exhibit 1 and attachments.
Any objections?
No objection, Judge.
All right, state, you may be excused. Did you review the waiver and consent to stipulations in each of these cases?
Yes.
Did you understand it and sign it in all the appropriate places?
Sí.
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Sí.
Yes.
In each cause number, the court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence State's Exhibit 1 and attachments, and the court will review the same.
Okay.
That's how you say okay in Spanish. Is it okay?
Sí.
It's common that they say okay, but usually when people say okay in Spanish, it's está bien, but okay is accepted.
Está bien.
Yes.
Before the year is over, I'm gonna learn how to say okay in every language. All right, after reviewing State's Exhibits 1 and attachments and each cause number, the court will find there was sufficient evidence to find you guilty, and the court will find you guilty in each cause number. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Nothing other than he's ready to start probation and he hopes to complete it as quickly as possible.
All right, do you have any children?
Sí.
Yes.
What are their ages?
8, 5 y 4.
8, 5, and 4.
I knew those numbers. All right, do they stay with you?
Sí, hablo con ellos, pero no están conmigo.
Well, I talked to them, but they are not with me at the time.
All right, do you buy,
They're with their mother.
all right, do you buy them gifts?
Sí.
Yes.
All right, are they boys or girls?
2 hombres y una mujer.
2 boys and a girl.
Okay. Now with your boys and your girl, I'm gonna say the girl. When she's old enough to start driving, are you gonna get her a car?
Sí.
Yes.
All right. So let's say she gets old enough, you get her a vehicle, right? She's gonna be excited about it. You're probably gonna put a bow on it. Who knows? Maybe it'd be for her 16th birthday, right? What type of car would you get her?
Un bonito que le gusta a ella.
A nice one that she would like.
All right. And I'm sure as a dad, you'll be proud that you got that for your daughter and that she's riding around in it, right?
Sí, claro.
Yes, of course.
And I'm sure your daughter is going to be a great daughter, so she's probably going to have a job or something too, right?
Yes.
Yes.
But still going to be in school and graduate, right?
Sí, sí, claro. Sí.
Yes, of course.
So let's say that she has a job and it's a nice job and she's working while she's still in school, getting great grades. And she goes to her job and they have her working in the back, right? She parks her car in the front. And let's say it's during the summertime, and usually teenagers, they have them working late in the summertime. And let's say she gets off of work at 10 PM and it's dark outside, right? And she comes out and her car is not there. And she's calling her dad. She's like, I know I parked it here, but it's not here. And she calls you and you come because you're still thinking maybe she parked it in the wrong place, right? And you find out that no, her car is gone. Somebody took her car. And then let's say you call the police and you discover her car and the steering column is damaged. Somebody maybe has been smoking marijuana in the vehicle, so you know it'll never be the same, right?
Yes.
So how would you feel about the person who did that to your baby girl?
Upset, very upset.
That's what you've been doing to somebody else. They come out, their vehicle is gone, and that's what you've been doing.
Pues sí entiendo eso, que yo lo mataba manejando, pero yo me fui la persona como que hizo eso exactamente, que me lo robé. Digo, yo no fui la persona que exactamente yo lo tomé de la persona.
Well, it's not, I didn't do exactly that. It's not like I took it from the person.
Yo sí estaba, pues sí estaba manejando, yo estaba consciente pues, que no era mío.
I was driving though,
Estaba consciente que no era mío. Sí.
and I was aware that it was not.
Pero no, como así, que yo fui a robármelos, a abrirlos, no, yo no hago eso.
But
Oh,
it's
no.
not,
There was marijuana in the car, but continue, I'm sorry.
but it's not like I went and I stole it and took it and opened it. It was not like that.
Let me ask you this. Let's assume this person steals your daughter's car. And they're before a judge and they're like, no, it's not like I stole the car or anything, but I was driving it. And then guess what ends up happening? They have another car that they're accused of stealing. What would you say to them? If you're in the audience, what would you say to them? And you're just listening.
No, pues está mal, está mal.
Well, that it's bad,
Hicieron mal, pues no está bien lo que están haciendo.
that they did something wrong and what they're doing is not right.
And see, the reason why I asked you that is because what are the chances in somebody's lifetime that they drive two different stolen cars, saying they didn't know they were stolen?
Pues, ¿cómo le digo? Pues por favor, no está bien, yo sé que no está bien esto, pero pues espero que todo cambie, quiero ser la mejor persona para no cometer los mismos errores que he cometido.
Well, how do I say this? I don't know. It was a mistake.
No,
I'm
I'm sorry, go, I'm sorry.
I don't know if it was a mistake. I'm trying to change so I don't commit the same mistakes again.
All right, these are not mistakes, these are choices. Because who is Angel Torres Casas?
I don't know him.
They say he was in the car with you. Maybe I'm mispronouncing his last name. It's Quezas.
I don't recall that name.
All right, and then who is Vivian Ortega?
Vivian.
Ella se me hace que viene siendo una hermana de una amiga mía, me parece. De una amiga mía.
She's friend of a friend of mine, I think.
Vivian, right?
Vivian?
Yes.
Parece que es.
I think so.
And who is Christy Jimenez?
I don't know her.
I'm sorry, Christy Jimenez Friday.
No.
All right, and who is Regina Ortega?
Ella es la amiga que está en común con la primera que me preguntó.
She's the friend that I have in common with the first one you asked about.
Okay. And are you employed?
Ahorita está por empezar.
Right now, I'm just starting.
Estoy pagando el bono y luego voy a pagar el provecho. Entonces,
I have to pay for the bond and also probation.
voy a pagar.
All right. This is what the court is going to do. And cause number 2025 CR 0033736. As previously stated, the court is finding you guilty. The court will sentence you to 2 years in the state jail facility, suspended and probated for 3 years. Regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors. This is to run concurrent with 2025 CR 003886. Restitution, if any, to George Torres. There's to be no contact with Vivian Ortega, Christie, Kristie Jimenez with a J, Friday, Regina Ortega. There's going to be 100 hours of community service restitution. I'm going to order parenting classes. Once he completes that, the parenting classes will be deemed satisfied. Field visits 1 time per month for 3 months. And that cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question on what a weapon or ammunition is, you'll need to speak to an attorney. And cause number 2025 CR 003886, the court is finding you guilty. The court will sentence you to 2 years in the state jail facility, suspended and probated for 3 years. Regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors. This will run concurrent with 2025 CR 003736. Restitution, if any, to Jared, Jarred, Elias McGarity. There's to be no contact with Angel Torres. The last name is Quezas. There's to be 100 hours of community service restitution. I'm going to order the theft course. Once he completes the theft course, the community service hours will be deemed satisfied, and field visits 1 time for 3 months. Probation, is there anything else that's needed? And that cost number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. You're gonna have to make better choices. What you did, those were not mistakes. Those were horrible choices. You're a grown man, you're an adult. You're supposed to be setting an example for your children. You understand? All right.
Yes.
Everyone wants you to be successful in this probation. If I didn't think you could complete it, I would tell them I would not follow this agreement. So if there are any issues, let your probation officer know about it. If you feel they're not addressing it and I'm here, you can still come back here, okay? Espen? De nada. You're welcome.
Thank you, Judge.
Thank you. Who is here on Matthew Rendon? Hello.
Afternoon.
Oh, afternoon. How are you doing today?
Nervous, but here we are.
Hey. All right. The court is calling 2024 CR 2339D State versus Matthew Rendon. Can I have parties announced?
Megan Galloway for the state. Victoria Cruz on behalf of Raymond Martinez for the defense.
All right, and are you Mr. Matthew Rendon?
Yes, ma'am.
All right, do you have any objections to this attorney standing in?
No, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor, defense is satisfied.
All right, court will find that the state is in compliance with discovery. Mr. Rendon, did you review the document entitled Deferred Adjudication or Community Supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we move to proceed on count 1 and waive and abandon count 2. No objection from defense.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
All right, you're charged with aggravated assault with a deadly weapon. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you understand?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in the prison?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Rendon, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $2,000 fine. If the court finds that a deadly weapon was used, there's going to be an affirmative finding of deadly weapon. The state recommends deferred adjudication, and there's restitution, if any, to Oscar Del Fierro. Fierro?
Yes, Your Honor. Yes,
All right. Did you understand that to be the plea?
Yes, ma'am.
Defense is at the plea?
Yes, Your Honor.
State is at the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 5 years. There be a TAP evaluation, 200 hours of community service restitution, no contact with Oscar Del Fierro, Anthony Cochran, Richard Campos, and the hostility management course. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charge, how do you plead to count 1? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offer states 1 in attachment. No objection from defense.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, please.
Anything you wish to say on behalf of your client?
Not at this time, Your Honor.
All right. Are you currently employed?
Yes.
What do you do?
My family has businesses. I do stocks on the side.
You say
Mostly-
stocks?
Yeah, like stock market, I'm an investor.
Oh, okay.
I do a lot of entrepreneurship. It's
Okay.
that category of work.
How's stock investment going?
I don't like to get political with it all.
No, no,
It
no.
affects it, but it's good. I make good percentages yearly, good.
No, I asked that. I have friends who do the stock market and they're always coming to me and I'm like, don't get married to the stock. Don't marry it.
It's a lot of discipline.
Oh, it is. All right. Do you have any children?
Yes, ma'am.
And what are their ages?
I have a 4-year-old son and a 3-year-old daughter.
Okay. All right, this is what the court will do. The court is going to sentence you to 5 years deferred adjudication. There's an affirmative finding of deadly weapon. There's to be regular reporting by Zoom or in person, regular random UAs, $2,000 fine probated. There's to be restitution, if any, to Oscar Del Furio. State, when do y'all want the restitution hearing set? All right, can I have 30 days for a restitution setting, please?
Yes.
And it may be a restitution amount that they agree on, but I've learned that when you don't set a restitution hearing, it just floats out there.
Yes.
And so I want you to be able to know what the amount is.
Judge, if you give me just a second, I'm looking up another court paper for Megan.
Okay.
I'm just trying to get it lined up with.
Oh, no problem. All right, while they're doing that, I'll continue. So there's going to be 200 hours of community service restitution. I'm going to order parenting classes. Once that's completed, the community service will be deemed satisfied. People always wonder, why do you order parenting classes? And the reason why I do it is because when people are making these choices, they need to think about their children as well. What would happen if I go to prison? And they're not really thinking about that. They're in the heat of the moment. And let me do this. There's going to be parenting classes, 100 hours deducted for the parenting classes. And then I'm going to order the hostility management course that was recommended. And then once you complete that, the remaining 100 hours will be deemed satisfied.
Thank you, Honor.
There's to be no contact with Oscar Del Furio, Anthony Cochran, and Richard Campos. And there is to be proof of employment within 30 days, no employment as a home health care provider or with minors. Probation, is there anything? Thank you. Field visits 1 time per month for 5 months. Anything else, probation? Is there anything else you need from the court in order to be successful?
No.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. Do we have a date?
July 24th.
All right, so what's going to happen on July 24th? We'll be back here, and that's for us to get an amount of restitution that is owed, and your attorney will have a chance to either object to that amount or agree to that amount. Do you understand?
Yes, ma'am.
So let me explain something to you. When people bring out guns, guess what? If you end up firing it and it ends up hitting someone, there's no turning back from that. You understand? So you're going to have to start thinking and putting your children at the forefront of your thoughts in everything you do, because everything that you do ultimately ends up impacting them. If you go to jail, even if you're in jail for 30 days, getting a bond, it's where's daddy. If you end up going to prison, it's where's daddy. And then that snowballs other thing, because sometimes you have women who will wait for you after you get out of prison. Sometimes they don't. And you know what that means? That means that somebody else that you don't know is raising your child.
Yes.
All right. If you need anything, let probation know. If you feel they're not addressing it, you can always come back to the court. Okay.
Thank
All right. Good luck to you.
May we be excused, Your Honor?
Yes.
Thank you.
Norma,
Yes.
I have Rodriguez Luna for tomorrow. Is he in custody?
Yes.
All right.
No, what is he? Right here.
Procardo Daniel Rodriguez Luna. All right, your case is gonna have to be recalled tomorrow. Your attorney is actually in federal court and they just gave us notice of that now. Come forward. I'm sorry. No, go back. I'm sorry. The deputies are in charge of security.
My bad.
All right. I'm sorry, Deputy Laura, forgive me.
Can't save you.
You're trying to save me. I'm gonna be in a Lifetime movie with a law named after me.
Hey, Mom,
Hi. Yes.
I was just wondering if getting you attorney. I've been contacting them, they haven't.
Who's your attorney?
Robert Fogg is judge and he'll be here tomorrow for the
Gilbert.
first trial.
Gilbert Campos? Gilbert Campos?
Gilbert Campos?
Yes.
No.
That's not it? Oh.
Robert
Robert Barnes?
All right, so this is what we're gonna do. Your attorney has said that he will be here tomorrow. So you be here tomorrow and we're gonna build that bridge when we get to it, okay?
Because this is my third time showing, he hasn't shown up or taken any of my calls. I called him, left messages before. There's probably
Okay,
a
so,
window.
all right, so here's the thing. I really don't like for people to talk about people when they're not here, right? Because just wait for tomorrow. I have it on the docket sheet that he knows to be here tomorrow. And we're gonna have you here tomorrow at 9 a.m. Of course, if we have another one of these historic storms, I will give people leeway because I want people to arrive here safely. So we'll have you come back here tomorrow, you sign the reset form, and we're gonna let you two meet and talk, okay?
Thank you.
All right.
Just one other.
Yes.
If I can get like a note that's saying that I have to be here tomorrow.
Oh, she's gonna give you a reset form and it's gonna show that
Then
you're
he's
required to be here.
probably firing me, but
Oh,
I'll tomorrow again.
You-
Yeah, I have a good reason, but you know.
Tell them you have to be here. You're not
That's the
trying to.
policy, they need a letter from
No, that, let me just tell you, when you have the reset form, it will show the 187th on it and everything.
Okay, thank you so much.
And they can always call the court and the court is gonna say he's scheduled to be here tomorrow at 9.
Okay.
All right.
That's all I. Thank you so much.
Thank you so much. Who's here on Jordan Armstead? Is there an application?
Yes, Judge.
Okay. Oh, come forward.
Did they get new signs for each court, the gold plaque?
Yes, they did. And they misspelled my name outside. They spelled it Stephen, no, Stepenie, 3 E's. Yeah. All right, the court is calling 2025 CR 0039110 State versus Jordan Armstead. Could I have parties announced?
Megan Galloway for the state.
Joseph Stateson for defendant.
And are you Mr. Armstead? All right, you're gonna need to speak up.
Yes, ma'am.
All right, I know you have some bass in your voice. The court reporter needs to hear it so I can hear it, okay? All right, counsel. Have you received all discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Armstead, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it? Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Judge, we need to proceed on count 1 and waive count 2.
Any objections?
None.
All right, and did you review the court admonishments?
Yes, ma'am.
And did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand in count 1, you're charged with unauthorized use of a vehicle? That's a state jail felony.
Yes.
The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes,
Wow.
ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Armstead, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on count 1. There's a $0 fine. State recommends deferred adjudication. There is restitution to censor, or is it sincere? Sinclair, it's,
I think it's, yeah, it's not with an E. The last one is it's an R in the indictment. It's
all right, so it's spelled Sincer Mendoza. Or is this Mendoza? Just once. All right, Mendoza, and the amount of $1,200. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 3 years. There be 200 hours community service restitution, top evaluation, no contact with Sincere Mendoza, and a life skills course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offenses charged in count 1, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Your Honor, the state offers states 1 an attachment, and then I do a couple one thing that I need to address.
Yes.
Very briefly. So in the paperwork, that is the agreement. However, I failed to include that the state is taking into consideration a misdemeanor case. That clause number is 2025 DC 001622.
Any objection to the court adding that cause number to the plea paperwork?
No, Your Honor, and I'm holding on to those documents. It's originated out of County Court 12, so my understanding is I'm going to hold on to these and approach
Yes.
County Court 12.
All right, thank you. All right. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge, and I have something to add at the appropriate time.
Yes.
Your Honor, I asked my client to do some upfront classes. I'm appointed. He was found indigent. He's unemployed. He's looking for work. He managed to take 1 class conflict-wise. I provided that to ADA Ms. Galloway. I would ask that if you could, it's not the same class that the state was asking for life skills, but I was asking if you can give him credit towards maybe some community service hours, if he provides that class certificate to probation. He had nothing to do with the robbery of Miss Mendoza.
Yeah, I see. They said it was
For Hispanic.
yes. And they described him as Edgar's
Correct.
because of the haircut?
All of them had the Edgar haircut. Correct. Clearly,
Okay.
he does not. And
No.
he regrets picking the keys up in the parking lot, but we agreed to a fixed amount on restitution. In the event that the complainant was seeking additional restitution, we would ask for restitution hearing. I discussed this with Ms. Galloway. I believe the complainant was gonna seek wear and tear damages and not collision damages. So we agreed to a number. There's no contesting the 1,200, but if there's something past the 1,200, we would want a restitution hearing.
All right. So how old are you? You should know better than pick up a key fob and start trying to see which part works to. You should have just turned that key in, and who knows, the person who owns the vehicle, maybe they will give you some kind of reward for finding their vehicle. Now instead, you have this felony that you're charged with. You know better, right?
Yes.
And you should know better if you're wearing that jersey. Yeah, I mean, that's Muhammad Ali. Did you see him stealing? And the times were surely hard for him. So if you're going to wear that, you need to represent what he represented. You understand? All right. How far did you go in school?
Okay.
Did you graduate?
Yes.
All right. What are you planning on doing with the rest of your life?
Russian basketball.
With who?
Like for semi-pro team, San Antonio Powerhouse.
All right. So what position do you play?
Shooting guard.
And are you making your shots? Mm-hmm. All right. And how are your free throws? Oh, please. He said, are they like money? Or are they like Shaq's free throws? Maybe, maybe not.
Maybe.
Okay. I never understood why would Shaquille O'Neal, they didn't let him know you're going to get fouled a lot. So we need to work on these free throws.
He got better through the years.
But you know what somebody said with his free throws? It's sort of like if you were trying to throw maybe a free throw with a golf ball.
Oh, right.
That makes it very difficult, you
Correct.
know, if the ball is so small in comparison to your hands. All right. Does he have any prior history?
No prior history. If the state had said no initially to pre-trial motion. But what essentially is happening now is if we give the state more time to look at the case, maybe have more time to do some process, we come back to a court setting, we may offer a motion program. Maybe they don't. But maybe in the best interest to contact the setting.
I'll tell you what I can do is I can set this for sentencing.
Mhm.
And the plea has already been taken. I've accepted your plea. So I can set it for sentencing. They'll have a chance to look at things.
And if things don't change, you're still getting the same deal. If things change, maybe it could be a little bit. You okay with that?
All right. So we're back on the record. The court is finding there's sufficient evidence to find you guilty. The court is deferring finding of guilt as you applied for deferred adjudication. Ms. Galloway, how much time do you need, you think?
Probably just 2 weeks. I need to just call the detective and speak.
All right. Do you want to set it maybe?
Thursdays and Fridays are my best dates.
You want to do July 10th, July 17th?
The 10th will work for me, and if things change, I'll reach out to Mr. Stateson so that we could get what we need to get in for our court date.
All right. And then Mr. Stetson, if you can hand me back the,
Certificate of appeal.
yes,
Yes, Judge.
thank you. All right, so we'll be back on July 10th.
Thank you, Judge. Have a seat.
You're welcome. All right, Norma, if you'll give him a July 10th reset date. And then the next, Mr. Outlaw. Court is calling 2025 CR 002531, 2025 CR 002532, 2025 CR 0023, I'm sorry, 2025 CR 002534, State versus Eddie Law Outlaw. Can I have parties announced?
Jason Garahan for the state, Your Honor.
Martin Guerra, attorney for Eddie Outlaw.
And are you Mr. Outlaw?
Yes.
Counsel, in each cause number, have you received all discovery and did you review it with your client?
Yes, Your Honor.
In each cause number, the court will find that the state is in compliance with discovery. Mr. Outlaw, in each cause number, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, in each cause number, do you waive the reading of the indictment?
Yes, Your Honor.
State in the cause number ending in 3-1, are you proceeding on the indictment as presented?
No, Your Honor, we're waiving the enhancement paragraph.
No objections.
And in count ending in 3-2, are you proceeding on the indictment as presented?
No, Your Honor, we're waiving that enhancement paragraph also.
No objections.
And in count ending in 3-4, are you proceeding on the indictment as presented?
Waiving the enhancement paragraph.
No objections.
In each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
In each cause number, you're charged with aggravated robbery. The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state calls, and the right to remain silent. Did you understand by entering these pleas, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in each one of these cause numbers?
Yes.
Counsel, in each cause number, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Outlaw, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
In each cause number, punishment is to be assessed at 16 years in the prison. There's a $2,000 fine, affirmative finding of deadly weapon. The cause numbers were run concurrently with each other. And the state will take in consideration 2025 CC 006439. Did you understand that to be the plea in each cause number?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
It is, Your Honor.
In each cause number, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No, Your Honor.
Then in cause number 2025 CR 002531, how do you plead? Guilty, not guilty, or no contest?
No contest.
And cause number 2025 CR 002532, how do you plead?
No contest.
And cause number 2025 CR 002534, how do you plead?
No contest.
State any evidence to support the defendant's plea?
Yes, Your Honor. In each of the cases, state exhibit number 1 with all of its attachments.
No objections.
In each cause number, did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would calling the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
In each cause number, the court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, in each cause number, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty in each cause number. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, he accepts responsibility for his actions. These were terrible mistakes. For many years now, he has been dealing with a drug addiction, and I think it's safe to say had he not had that addiction, these offenses would not have taken place. Because of that, we are asking if you could put in the judgment that he be placed in a therapeutic community.
All right, the court is going to sentence you to 16 years in the prison. There's a $2,000 fine. Time and money will run concurrent. There's an affirmative finding of deadly weapon. And this is in cause number 2025 CR 002531. This will run concurrent with 2025 CR 002532, 2025 CR 2534, taking consideration number 2025 CC 006439. And the court will request the therapeutic community. And cause number 2025 CR 002532. Court is finding you guilty. The court is sentencing you to 16 years in the prison. Give you credit for any time served. There's a $2,000 fine. Time and money to run concurrently. There's an affirmative finding of deadly weapon. This will run concurrent with 2025 CR 002534, 2025 CR 002531, taking consideration 2025 CC 006439. Court will request the therapeutic community. And cause number 2025 CR 002534. Court is finding you guilty. The court will sentence you to 16 years in the prison. Give you credit for any time served. There's a $2,000 fine. Time and money to run concurrently. There's an affirmative finding of deadly weapon. This will run concurrent with 2025 CR 002532. 2025 CR 002531. Take in consideration 2025 CC 006439 and request the therapeutic community. Is there anything else with regards to sentencing?
No, you.
All right, in each cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, and each of these cause numbers, because these are plea bargain agreements, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. Oh, I'm so sorry. And in 2025 CR 002534, again, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
And because it's a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes.
All right, so here's the thing. You're gonna have to start making better decisions. Otherwise, you're gonna spend the rest of your life in prison. Do you understand?
Yes, sir.
And if you have a drug or alcohol problem, there are plenty of places that are free in San Antonio that will help you. When you're released from the prison, if you cannot find a place that will help you, if I'm still here, you can come back here and I will find a place for you. Do you understand?
Yes. Opiates.
Opiates?
Yes, sir.
Well, they have locations that handle opiates and alcohol as well, okay?
Yes, sir.
So you're gonna have to get control of that. Otherwise, you're gonna spend a lot of time at the prison. You understand? All right, good luck to you, okay?
Thank you, Judge. Here's the dismiss.
Okay. Okay, so here's the thing.
Let me just,
Some misdemeanor courts don't want us to sign these, so they have to sign them. Okay,
well, I can run it over.
all right, thank you. All right, do we have anyone else on the docket?
That's it, Judge.
All right, yes. All right, we'll be back tomorrow for bench trial.